Well, welcome back, ladies and gentlemen. I'm just going to explain again very briefly how the afternoon is going to work. Now, we're having a mock arbitration on the agreed facts set out in that bundle, which I hope you've managed to at least have a little look at. There are two issues to be determined. A, were the charterers in breach of contract in ordering the vessel to the discharge port? And B, if the charterers were in breach, did that breach cause the loss in respect of which owners are claiming damages? Now, you see before you a relatively straightforward arbitration setup. On the stage in the middle, you'll see three arbitrators. Starting from the left, Mr. Robert Shaw from New York. Robert, in fact, is an English lawyer and an American lawyer, had a distinguished career with Healy and Bailey and has then since moved into industry and is a committee member of the SMA. On the right, Jude Benny, a senior Singapore lawyer, senior partner of Joseph Tan Jude Benny in Singapore. And in the middle, your chairman, Mr. Bruce Buchan, who is a committee member of the LMAA and who represents the English arbitrator. Also two tables. On your left, you'll see Chirag Karia, representing owners, instructed by Ince & Co., represented by Ian Chetwood, and their client, Mr. Satsas, who you've seen this morning. On the right, Neville Phillips, counsel for the charterers, instructed by Helen McCormick from Holman Fenwick, and their client, Mr. Han van Blanken. And we're going to try and follow as much as we can the formula of a traditional English arbitration. The owners are the claimants, they will open, charterers will respond, and their witnesses will be called. The argument's on the basis of English law, obviously, and that's clear because of the Charter Party, but I have asked the arbitrators to decide the issues on the law of their domicile, so to speak. So in other words, Mr. Buchan will be rendering his decision on the basis of English law, Mr. Shaw on the basis of American law, and Mr. Benny on the basis of Singapore law. They may be identical, they may be different, they may be somewhere in between. This should last between 1.5 and 2 hours, and then there'll be a tea break when the arbitrators will go off and consider their decision. I'm then going to ask you what you think, what the answer should be. Should it be owners? Should it be charterers? Should there be some other kind of cross remedy? Now, although I'm going to ask you, what actually will happen is that on the screen up here, in due course, maybe now, I'm not sure, there'll be an interactive voting slip right at the top, and you can vote at any time during the afternoon, saying whether you think the owners or the charterers are liable. You can change your mind at any time, but obviously when we come to the tea break, we're going to close the voting down and we'll see how you voted. There it is. So that will change all the time as we go along as you vote, and you can vote as, rather like the Irish, vote early, vote often. But, so you can carry on voting as long as you like, right up until tea time, and hopefully you'll be persuaded one way or the other, either by Mr. Correa or by Mr. Phillips, as to what the answer should be. So let the arbitration commence.
Yep. May I please you, gentlemen? We've agreed we're going to have a 5-minute opening for each side. What I propose to do, if I could ask you, gentlemen, to take tab 1 of your bundle, and I hope to take you very swiftly through the pertinent facts. Paragraph 2, you'll see, gentlemen, that this is an NYPE form 1993, and that's going to be relevant. You actually have the form in the bundle, and we will look at it when we get to the closing. As regards the safe port and safe berth warranties, they appear in the preamble, which you see at paragraph 7, and there is a specific clause, clause 6, that deals with safety and provides that the discharge shall be at a safe dock, safe wharf, safe place in port, and the vessel can lie always afloat, safely lie always afloat. The next key document is set out at paragraph 13, and this is very important. These are the charterer's voyage instructions. What the orders are to load a full and complete cargo of 21,400 metric tons plus or minus 10%. And the loading is to be at the safe port in Thailand, and the discharging, and this is important, 1 to 2 safe berths, Port Lindsay, West Coast, USA, where vessel's arrival draft not to exceed 30 feet fresh water. In the event that the draft in the river is below 30 feet fresh water, the port will arrange lighterage to the prevailing draft at their expense. So we're being told that we can load up to 30 feet fresh water, and we're to load, well, the loading has to be a full and complete cargo. And when we go to look at the NYP form, you will see that the loading is actually not carried out by the owners, it's carried out by the charterers. And it's indeed they who have the decision as to how much to load, whether it's plus or minus 10%. But be that as it may, we're told that this is the quantity that should be loaded and the arrival draft not to exceed 30 feet. And certainly when the vessel got to the port, the arrival draft did not exceed 30 feet. The next documents you see on the next page, these are the various charts and Admiralty pilots that were on board. And when one looks at the emails that passed between the parties, and those, gentlemen, you will see at the end of the facts, you will see that as of the 19th of June, the owners were concerned about the safety of the berth and the port, and were asking for confirmation from the charterers that the port was safe. The charterers repeated essentially what was in their voyage instructions, that the advertised draft is 30 feet fresh water, and the owners will make sure that the vessel arrives with that arrival draft, and she did. On the 24th, that's the next email, gentlemen, middle paragraph, owners are very concerned, master has been instructed to wait. Final paragraph, owners now feel that the situation is a serious problem and are considering instructing the master not to proceed. Owners urge the charterers to arrange lightering at the anchorage as owners are now concerned as to the safety of the vessel. Please confirm by return that the charterers will consider lightening. Next page, and I apologize for rushing through this. Next email, email number 4, third sentence, charterers are cargo owners and have a deadline for commencement of discharge and are therefore anxious that the vessel comply with charterers' orders immediately and proceed to the discharge area. Charterers remain committed to abiding by the terms of the charter and can give no further assurances. However, they do say, we have had previous experience of vessel using this port during periods of heavy rain without any problems. And gentlemen, we'll look at that. Finally, you have an email which we say is a crucial and revealing email on the 25th from Mr. Satsas on behalf of the owners, referring to the oral exchanges that he had with Mr. Van Blanken, where he expresses his gratitude for charterers' confirmation that they are anxious for this vessel to discharge. They are able to confirm that they will hold owners harmless from any loss and or damage that the vessel may sustain. And you'll see, gentlemen, that that's the third issue that you gentlemen have to deal with. There are 3 issues. 1, whether there was a breach of the safe port warranty. 2, whether that caused the loss that's been claimed. And 3, regardless of that analysis, whether there was an express hold harmless agreement between Mr. Van Blanken and Mr. Satsas. So I think that's my time, and it's over to my learned friend.
Gentlemen, my learned friend has addressed you very briefly on the facts and has intimated, at least in some respect, what his case is in terms of liability. You'll have had the benefit of a detailed skeleton argument from us, which articulates at some length how we approach the dispute. In essence, we say that this is a paradigm case of a grounding which takes place in circumstances where there is plainly no breach of any safety warranty, and in which, if there were to be any dispute about the matter, was plainly the consequence of negligence on the part of the master. And the threshold for both of those arguments is an observation to the effect that the owners were the party which, from the outset, actually determined the draft to which this vessel loaded. My learned friend says, well, if you look at the NYP standard form, it says that the charterers are the ones who are responsible for loading the vessel. True it is, the charterers are the ones who are responsible for physically undertaking the act of loading, but it's the owners, in this case, who had the option as to the quantity of cargo to be loaded. So there is a clear distinction between those two concepts. The first is, it's the owners who say, okay, we have an option as to how much to load that much. And the charterers then say, okay, we will now take on the responsibility of loading that quantity of cargo. And our position is that this case is slightly unusual in that at the time that the voyage instructions were given, and that is the stage at which the safety of the port has to be prospectively assessed. So at the stage at which the voyage instructions were given, this port was safe for the vessel, provided that she was loaded to a draft which would accommodate the physical restrictions of the discharge port. And those physical restrictions were known at the time that the voyage instructions were given. Because at the time that those were given, or very shortly thereafter, the master had available to him the relevant chart for the discharge area, which itself stated in express terms that there was a draft restriction of 9.1 meters. So a prudent master, we will submit, would have known from the earliest possible stage that his draft should not exceed anything which could safely accommodate available water of only 9.1 meters. Now, that of itself, in my submission, is a fundamental stumbling block for the owners in this case, because it's quite clear that the vessel was actually loaded to a draft, to a freshwater draft, which was in excess of 9.1 meters. So from the word go, the vessel had been loaded to a draft which actually exceeded that which the chart itself stated was the maximum available freshwater depth. One then has to add to that the fact that a prudent master, and gentlemen, you're an experienced tribunal, and I would invite you to, as it were, have arbitral notice of this fact, that a prudent master, as part of the fundamental requirement of safe and careful and comprehensive passage planning, would take due account of two things when assessing the draft to which to load and whether his vessel can safely undertake the passage. One is the need for adequate under-keel clearance, and the conventional allowance for that, the rule of thumb, as it were, is well known as being 10% of your vessel's actual draft. And the second is, and this is of particular importance when navigating in a river, is that you have to allow for squat. And that allowance has to be made by reference to the speed of the vessel through the water. And what is very clear in this case is that the master made no calculable allowance for under-keel clearance. All he did was load his vessel to a particular draft and then insert in the relevant voyage documents the difference between that draft and what appeared to be the maximum available draft according to the Admiralty pilot. Well, that isn't under-keel clearance allowance. And when it came to squat, the master's own evidence in the harbour inquiry in the United States was to the effect that he had calculated squat to the extent that he had done it at all by reference to the speed of the vessel over the ground, which was entirely wrong. Wrong in principle, as a consequence, wrong in terms of the mathematics, and as a further consequence, entirely inadequate and inappropriate. Had the master actually met his obligations under the United States Carriage Goods by Sea Act in any of those three respects, the draft to which the vessel was loaded, under-keel clearance, and squat, this vessel would not have grounded. Alternatively, if the master was at any stage left in any doubt, and there was ample reason on the factual evidence for him to be placed in doubt, the obvious thing to do, the prudent thing to do, was not to proceed. But this master threw caution to the wind and elected to go ahead. And that is not something in our submission for which the charterers should bear responsibility, as a matter of law or as a matter of fact.
Gentlemen, I'll call my witness. Mr. John Tsatsis, please. Sir, do you propose to remind the witness of the importance of the truth of his evidence?
Yes, I'm sure you're well aware of it. We participated in these matters before, so you are aware of the necessity for the truth. Thank you.
Yes.
Mr. Tsatsis, could you please get your bundle? I apologize. I should have
Apologies. No, don't put.
You will see there at tab 4 a document entitled Witness Statement of John Tsatsis.
Yes,
Is this your witness statement?
it is.
Yes. And at page 5, you will see a signature block, but I take it yours has a signature on there.
It is.
And are the contents of this statement true?
They are.
Yes. If you just wait there, my learned friend will have some questions for you.
Thank you.
Good afternoon, Mr. Tsatsis.
Good afternoon.
Tell me, are you a mariner?
No, I'm not.
Do you have any experience of navigation and the calculation of allowances for squat and under keel clearance?
Not beyond my basic knowledge, no.
In paragraph 8 of your statement, you say that you received an email from the master on the 19th of June 2010, which warned of critical areas and frequent changes in depth. You see that?
Yes?
At that stage, did you know any of the information regarding the vessel's actual draft?
What I knew is that the vessel had been instructed at the load port by the charters to load to a particular draft.
Well, that's not correct, is it? The vessel, let's just be clear on that. The charterers had issued voyage instructions which allowed the vessel to load up to a draft of 30 feet fresh water. But the option as to the amount of cargo to be loaded was left with the owners and the masters. That's correct, isn't it?
Well, I have some difficulty with that because I felt that the orders that were given by the charters were quite unequivocal in the sense that there was no incentive for the vessel either to load more cargo or less cargo. The only incentive was to comply with the charter's orders.
Well, that may be right, but putting aside the question of incentives, in whose final option was the actual quantity of cargo to be loaded?
I would just put a marker down to the extent my learned friend is seeking to ask a question of law that relates to the construction of these instructions, then this is not a matter for this witness.
Well, I'm not asking Mr. Tsatsis questions of law, gentlemen. I'm asking Mr. Tsatsis as to his understanding of what the position was at the load port.
Right. My understanding was that the vessel was ordered to load to a draft of 30 feet fresh water arrival at the discharge port.
All right. And what information did you have at the time you received the email from the master on the 19th of June as to the vessel's actual draft?
I have difficulty recalling exactly what it was, but as far as I'm aware, the master had said that he would arrive on the specified draft, just under.
And what information did you have regarding the depth of available water in the arrival channel?
Well, that in itself was rather confusing because what we were being told as the owner's representatives was that the harbour authorities were saying one thing, the charters were also concurring with what the harbour authorities were saying, but the Pilots Association was saying something altogether different.
And so in paragraph 9, you give the impression that the master's message caused you some concern.
Yes.
Why was that?
Well, if there is a doubt between the harbour authorities and the Pilots Association as to the true state of the channel in the river, I have to say that that to some extent is influenced by circumstances prevailing at the time, and there were supposed to have been heavy rains which affected the soundings, and also there was some intimation at that time of there being obstructions on the bottom of the channel that were not charted.
So if I were to paraphrase, what concerned you was uncertainty as to whether it would be safe for the vessel to proceed.
Yes?
And so against that background, you emailed the charterers and you sought a black and white confirmation that the port was safe for the vessel.
Indeed.
And in paragraph 10, you say that Mr. Van Blanken responded and said that he had, quote, no reason to suppose, unquote, that it was unsafe.
Yes.
And he referred to the advertised draft of 30 feet and stated that the charterers would comply with their obligations.
Yes.
And so in paragraph 11, you say you decided to review the situation with the master, and if needed, you would review it with the charterers once the vessel arrived.
Yes.
Yeah. So you were of the view that certainly at that stage, you hadn't received any unequivocal confirmation or assurance from the charterers that would, as it were, salve your conscience and give a green light for the vessel to proceed.
Absolutely.
Then in paragraph 12, you go on to say that the master contacted you on the 24th of June, that's 5 days later, and he told you that the pilot had said that the soundings were changing rapidly due to heavy rain. You've already referred to that. That the existing soundings were out of date, and that the pilot was concerned about shallow patches that were moving. And then in paragraph 13, you say the master also informed you that the vessel's draft was a little below 30 feet.
Yes.
Yeah. So you already...
Which was, may I clarify that, which was better than what was instructed.
Yes. So you already knew from Mr. Van Blanken, if not from the master, that the advertised available water was 30 feet.
Yes.
And you say in paragraph 5 that the owner's approach to management and employment is prudent and careful.
Yes.
Would it not be prudent, or would it be prudent for a vessel to proceed at more or less the same draft as the available water? In your experience?
The draft, you've got me unprepared there. The permissible draft, as I understood it, was 30 foot fresh. Not that the prevailing draft was 30 foot fresh. It was the permissible draft, and the ship was better than 30 foot fresh.
Did it trouble you that the vessel should have had something more by way of, as far as you were aware, the actual underkeel clearance that she had?
No, I don't think so. I think it was quite unequivocal that if the permissible draft, as defined by the harbour authorities and as advertised, was 30 foot fresh, then the draft for the ship was 30 foot fresh. I don't believe that there was an issue at the time of there having to be further allowance.
On the 24th, the same day, paragraph 14 of your statement, you emailed Mr. Van Blanken again, and you again articulated your concerns. And that presumably again is because at that stage you still hadn't had any confirmation or assurance from him that would satisfy you.
Correct.
And then Mr. Van Blanken responds to that, and you refer to that in para 15, and he says that he did not think that there would be any difficulty if the vessel proceeded, but he stated in terms that he could give no further assurances. Do you recall that?
That is correct, and he said that the maximum advertised draft was 30 feet. He didn't say that the maximum available draft was 30 feet. He said the maximum permissible draft, the maximum draft in the port.
But he said he would give no further assurances.
He did at that stage, yes.
And then he went on to say, didn't he, that he would discuss things with charterers, operations and management, and he would come back to you.
Yes, because I had said at that stage, or immediately before, immediately after, I can't recall at this particular juncture, that that was not good enough.
And so at that stage, you still haven't got any unequivocal assurance.
That's right.
Or any form of agreement. And so it was still at that stage in your lap, as it were, in the owner's lap, to decide how to proceed.
Yes, and we had said at that time that we would not proceed unless the ship was lighted.
And then Mr. Van Blanken said he would give you a call once he'd spoken to his operations and management people. And did you have the impression, therefore, that he could actually himself give you any assurance before he spoke to them?
Presumably not, if he had to obtain authority. Elsewhere, yes.
And then after that, the master informed you that the pilot had advised him of these obstacles.
Yes.
And you refer to that in para 16. And you then spoke to your managers and concluded that charterer's stance was not acceptable, as you put it.
Yes.
And your managers still wanted the charterers to arrange lightning, correct?
Yes.
But that, if that wasn't possible, you wanted some form of hold harmless agreement.
That is precisely right.
Now, all of this stems, doesn't it, from concern on your part that it wouldn't be safe for the vessel to proceed.
Yes.
And so what difference to that judgment would it make to you if you had a hold harmless agreement? Surely, if you're of the position that the vessel shouldn't proceed because it's not safe, that's the start and the end of matters, isn't it?
Yes and no, because I was being assured by the harbour authorities and by the charterers themselves that we were creating a storm in the teacup.
So would it be fair to say that at this stage, in your mind, the risk of damage was small enough to mean that it could be assumed? You could take the risk because you could rely on what the harbour authorities were telling you?
Well, the governing element has to be the harbour authority. Now, to what extent the harbour authority wants to promote its facilities as being capable of handling A, B, or C is not something that we were prepared to go into. What gave us concern at the time, and I say us to include the managers of the ship and the owners, as it was being conveyed to me, was that they were saying one thing and the pilots were saying another.
Yes.
So there was grounds for doubt in our mind.
So you then had another conversation with Mr. Van Blanken, and you told him that his existing vague reassurances were not enough. Mm-hmm. Yes, paragraph 21. And at that stage, Mr. Van Blanken still didn't give you the unequivocal assurance that you wanted, did he?
No, he did not.
And he still made it clear that he would, if his position could change in that regard, that would only be after he had spoken to his operations people, and he would come back to you if he had anything further to add.
Yes, in a sense, the pressure was already on us. He was explaining that our insistence that the vessel be lightened was creating serious commercial problems for them, and that as far as he was aware, there was no reason why we should persist in this concern of ours that the vessel was in any way in any threat.
So again, to paraphrase, what Mr. Van Blanken was saying to you is, look, in my view, you've got nothing to worry about, so just crack on.
Yes, and there was an inference at the time that by virtue of the fact that we were causing them a great deal of commercial hardship, I think there was a veiled threat that if we didn't proceed, there would be issues of off-hire, there would be issues of consequential events if we insisted on a situation that was not, at the time, practically feasible.
And so in your mind, there was an inference of an assurance from him?
Not at that stage.
Not at that stage. We're nearly there, sir. The rug is ever so gently inching from... Mr. Satsas, we'd reached the stage, I think, where there wasn't, at the stage of this conversation, any unequivocal assurance. And Mr. Van Blanken had said to you, I will speak to my operations guys, and if I've got anything to add, I will come back to you.
At that stage, as I understood it, we were required to proceed. And he said, you know, unless I can change that, the vessel is expected to proceed as ordered.
And then after this conversation, you sent Mr. Van Blanken the message which we see exhibited to your witness statement, and it's page 5. It's the very last exhibit. Do you have that?
Yes?
And in that message, you say, I refer to our exchange of messages and to our recent telephone conversation, grateful for charterers' confirmation that as they are anxious for this vessel to discharge cargo, they are able to confirm that they will hold owners harmless for any loss and or damage that the vessel may sustain, and so on.
No, that's not correct. That message was sent after I had a discussion with Mr. Van Blanken at a later stage, at which point I had made it abundantly clear to him that the vessel would not proceed unless the vessel were lightened.
And the way in which you phrased this message is such as to say to him, in effect, I should be grateful for your confirmation.
Well, I'm not looking at the English of it. What I'm saying at this moment in time is we had reached an impasse. He would not agree to lightening. We did not agree to proceed upriver.
I understand.
So at that point, we were at loggerheads. And
so
the way that that matter was dealt with is I said that the only way that the vessel would proceed is if we had an unequivocal undertaking from the charterers that they were responsible for everything that would happen as a result of us proceeding up the river. And he objected to that. He found that I was perhaps twisting his arm too much. I said, I have no option as far as that is concerned. The only way we will proceed is on that basis. And at that stage, he said, fine, fair enough. We'll have to live with that. And at that point, that message, we hung up and we sent that message that you referred to.
But why does your message refer to what you appear to suggest to be charterers' motivation for what you say was an assurance? When you say, grateful for charterers' confirmation that as they are anxious for this vessel to discharge cargo, they are able to confirm, and so on. Why do you refer to their motivation if you've already, in your evidence, you've already got a firm agreement with them?
Well, simply because the charters said that they have no option but to offer us this undertaking that I demanded. And that to some extent they weren't forced into agreeing to something like that.
Is the true position not that this message is actually a request by you for an agreement which has not yet been reached?
Not at all. It was the consequence of our discussion, which ended up in saying, we're not going. They were saying, we can't lighten, and we said we would proceed if you hold us harmless.
Is not the true position that this was a request for an agreement, you got no response to that because Mr. Van Blanken didn't come back to you, and because in your mind the risks of proceeding were minimal, you decided to take the chance?
Not at all. We agreed that we would only proceed on the basis of the assurance that we were given.
And if that's correct, Mr. Satsas, when you had your telephone conversation with Mr. Van Blanken at 3 a.m. on the day of the casualty,
yes,
why didn't you mention the agreement to him?
I did. I said we have bad news that this has caused the vessel to ground. I don't see the point in saying that we had come to some sort of an agreement as far as the message. I said, I made reference, I'm fairly confident I did, that I made reference to the discussions we had had leading up to this situation.
Well, we saw evidence of your discussion with Mr. Van Blanken earlier today, and when you spoke with him at 3 a.m. on the day of the casualty, you made no mention of the fact that you had this hold harmless agreement with him. That would have been the obvious thing to state, wouldn't it?
At 3 a.m., I don't know exactly what I was saying. I was woken up by a most unpleasant incident, which involved pollution, it involved grounding of the vessel, probably serious loss of use. I wasn't looking at my exact expressions to my counterparty.
I'm very grateful. I hope that this incident has been more pleasant and more awakening. Thank you.
Thank you.
No re-examination, gentlemen.
Thank you.
Gentlemen, if I may call my witness, Mr. Van Blanken. Mr. Van Blanken, if you'd like to take a seat. Mr. Van Blanken, would you turn please to tab 5 of the bundle, and hopefully we see there a witness statement with your name on it.
That's correct.
And if we turn to the rear of that witness statement, is that your non-existent signature that we don't see?
That's correct.
I'm very grateful. Are you content that this document should represent your evidence before the tribunal?
It does.
I'm grateful. If you'd like to wait there, Mr. Corrier may have a couple of questions for you.
Good afternoon, Mr. Van Blanken. How long have you been working in the shipping business?
I would say for some 30 years.
30 years. And is that as for owners or for charterers or a mixture of both?
Mixture of both.
And is that in fixing or in operations or both?
Both of them.
Both of them. Now, we know, and in fact you state in your paragraph 13 of your statement, that the charterers were desperate to have discharge commenced before the 30th of June. That's correct, isn't it?
That's correct.
And the only way you could achieve that is for the vessel to sail directly to buoy 7 without lightning.
That's also correct.
And that was precisely what the charterers were ordering the vessel to do.
Exactly.
And in the face of concerns from the owners, you were urging them to comply with the orders that you had given, weren't you?
I did, yes.
Yes. And if we look at the first email that's appended to your statement, you'll see from email number 1, dated the 19th of June, that the owners, the master and the owners, were very worried about the risks posed by proceeding to buoy 7.
That's correct.
And they were determining, the owners were demanding that the charterers confirm that the port is safe.
That's also correct.
And unless you reassured them that it was safe, you could not meet your 30th of June deadline.
I was given to understand that by Mr. Tsatsas, but I never could give him more assurance than I had given him already, because I just gave him what I received from the port authorities and the pilots.
Well, we'll look at that more carefully. But it was your strategy internally to encourage the vessel to perform by reassuring the managers.
Well, obviously we are a chartering company with cargo interests, and we have deadlines to maintain. So yes, of course I was pressing Mr. Tsatsas to get on with it.
Right. And you decided that the way to get him to get on with it was by reassuring him about the safety of this port and this berth.
I just gave him the authorities I had.
And in your second email, in your response to the charterers, you see on page 2, do you have that email?
Yes.
You you say that the charterers had no reason to suppose that the port was unsafe and that the advertised draft for the port was 30 feet fresh water.
That was correct, yes.
That's right. And you believe that to be true, did you?
That was the information I had from the port authorities.
Yes. No, you also believed that there was no reason why the port should be unsafe for this vessel.
Exactly.
Right. And you believed that provided the vessel's freshwater draft was 30 feet fresh water or below, she would then be safe.
Yes.
So as far as you were concerned, this was a storm in a teacup because you knew that the vessel's draft was below 30. The advertised draft was 30. So really you couldn't understand what the problem was that Mr. Satsas was talking about.
Well, exactly. I mean, I gave him the authorities, the information from the authorities I had. So I was like, if you want to have more information, and that's what I told him a number of times, on a number of occasions, you should ask the port authorities and the pilot. I'm not the one to decide. I'm sitting here behind my desk in Europe, and I'm not there at the scene. So I can't decide about that.
And if we look at your page 3 of the emails, if we go to page 3, this is on the 24th of June, and by this time the charterers are very concerned because of shallow patches in the river. And at this point, the owners are telling you that the master has been instructed to wait at the anchorage and obtain further soundings and a letter from the harbour master. You remember this email?
Yes, I remember.
And the owners were telling you it's a serious problem and they were urging you to lighten. Do you see that?
Yes.
And that they were considering instructing the master not to proceed unless you did lighten.
Yes, that's correct. That's what Mr. Tsatsa said.
Now that was a very serious problem for you, wasn't it? Because you couldn't lighten in time to meet your 30th of June deadline.
Well, for me it was a bit of a strange situation because the ship was at a draft where she should have been able to go up the river, so I couldn't see the problem for Mr. Tsatsa in that respect.
So you then, if we look at your response to that, you say the charterers refer to owner's recent email. Charterers point out that the port advertises that vessels with a 30-foot draft are perfectly able to enter, use, and leave the relevant discharge area. That's just what you've told us now.
That's correct, yes.
And the charterers are cargo owners and have a deadline for commencement of discharge and are therefore anxious the vessel comply with the charter's orders immediately in proceeding to the discharge port.
Yes.
And then in the next paragraph, you say, we have had previous experience of vessel using this port, also during periods of heavy rain, without any problems. Do you remember that? Yeah. And the reason you told them that about your previous experience was, again, to reassure them and persuade them to go to Buoy 7.
It was just a reassurance, because if there had been ships before, why should there be a problem for Mr. Tsatsas and his vessel?
But that statement was false, wasn't it?
No, it was not false, because it was what I knew at the time.
But it's not correct, was it?
At a later stage, I found out that we have had a vessel a number of years before which slightly touched the bottom without any damages. But I only knew that after I had consulted the rest of the company, who told me that somewhere 4 or 5 years ago another incident happened.
Yes. And you learned, yes.
At the moment I was speaking to Mr. Tsatsas, we didn't, I mean, in the 5 years before, I didn't know that.
No. But you actually learned the very next day that the statement that you had made to Mr. Tsatsas was false, didn't you?
Well, it was not a false statement. At the moment I was making the statement to Mr. Tsatsas, it was my belief, and that was also my experience from the previous years, that we hadn't had an issue there.
Let's take it step by step. You told Mr. Tsatsas that you had been using this port during periods of heavy rain without any problems. You told him that on the 24th of June,
That's correct. That was also correct.
That's right. On the 25th of June, you learned that the statement that you had made to him, honestly at that time, was incorrect.
That's correct, yes.
And the vessel still hadn't yet gone up the river, had it?
I think it was in the process of going up the river. I'm not so sure about that moment anymore.
And you didn't go back to Mr. Satsas and say, by the way, you know, I told you that we had no problems. That wasn't actually true. It was incorrect. I didn't mean to mislead you, but I now need to correct what I told you. You didn't do that, did you?
I didn't go back to him because that happened 5 years before, and as you have heard from Mr. Tsatsas in his statements and seen in the statements as well, it seems that the river is changing all the time, so I didn't consider that logical to discuss it with Mr. Tsatsas.
Hold on, but when you told him you had used this, we had previous experience of this vessel using this port, you didn't have any time frame for that, did you?
But we also had vessels that were in the period between that incident and between the incident with the Idle Star have called that same port.
And the reason you didn't correct your statement is because in your own words, the cargo was important and required with some urgency. That's why.
No, it just happened in the course of the conversation, not on purpose.
And on the 25th, when you knew that what you had told Mr. Satsas was false, you made a deliberate decision not to correct that inadvertent error, didn't you?
No, it didn't go that way.
And in your statement, paragraph 17, you say you saw little purpose in reverting to Mr. Satsas upon learning that you had inadvertently misled him. But Mr. Van Blanken, isn't honest dealing sufficient reason to correct what you have mistakenly said?
I didn't, as I said to you, at the moment in time that I made a statement to Mr. Tsatsas, I was not aware of that incident. So in the period between that, and which I found out a day later, that incident happened, and between the calling of the Idle Star at the same place, we have had many more ships. So I didn't think it was relevant, because all the other ships didn't have any problems.
The real reason you didn't is because you knew that if you had corrected your statement, Mr. Satsas would not have agreed to allow the vessel to go to Buoy 7.
That's not true, sir.
And I suggested to you that not only is that not an open or decent thing to do, it's not an honest thing to do. Once you've realized that you've misspoken, you should correct what you have said.
I simply didn't see the point, because we had had many more ships that called without problems.
And then Mr. Satsas called you on the morning of the 25th of June. Do you remember that conversation?
Yes.
And he told you that the owners wanted the vessel lightened if you wanted the vessel to go to Buoy 7. You remember that conversation?
Yes.
And you told him that that was commercially impossible because there were no lightning facilities and it would take weeks. Do you remember that?
Yes, that's correct.
And the reason why it was commercially impossible is, again, because you would miss your 30th of June deadline.
I didn't see any point in delaying the vessel any further, because with the draft as she had, she could go up the river, according to my opinion.
And then he demanded that you agree, the charterers agree to hold the owners harmless, didn't he?
I never told him that I would hold him harmless.
No, I'm asking you what he asked you.
That is what he asked me.
That's what he asked you. And that took you by surprise, didn't it, that request?
Yes, because I thought it was really strange, because the ship was at the right draft to go up the river. So why should you ask more guarantees than what he had already been assured by the port authorities?
And you tried to avoid answering that question, firstly, didn't you?
I wasn't trying to avoid it. I simply saw no point in answering it.
And you thought that if you confirmed that the agents had confirmed that as long as the vessel arrived with a draft of no more than 30 feet, you would be safe, that might clinch the deal, didn't you?
Well, that was not my reasoning. My reasoning was just the facts that the port authorities had given me details, and that the ship was, according to those details, suitable of going up the river.
Right. And at this point, when you talked to Mr. Satsas, you didn't know about the previous grounding, did you?
That's correct.
That's correct. So you had no reason to worry about the vessel grounding if she went as she was because of the advertised draft and everything that the harbour authority was
At that
telling you.
stage, I was not even thinking about the grounding, because the vessel was in confirmation with the draft
That's right.
restrictions.
And given that you were not concerned about the safety of the vessel, and the only way the vessel could go to Buoy 7 was by giving the hold harmless agreement, that's what you did.
No, I didn't give any guarantee to Mr. Tsatsas. I kept repeating to him that if he wanted to have more guarantees than what I had given him already, which were the guarantees I was given by the port authorities, he should go to the port authorities himself. I can't give any authorizations beyond my details.
And you were essentially trapped because you had to get the vessel to buoy 7 by 30th of June. Mr. Satsas was refusing to allow the vessel to go unless you gave a hold harmless agreement. And ultimately, that's what you did. You agreed to a hold harmless agreement, didn't you?
No, I never agreed that to him.
And the reason you didn't worry about agreeing to that is because at that point, you were convinced that the port and the berth was safe for this vessel.
I was convinced that the berth and the port was safe for the vessel because we had had many more vessels of the same size in the previous years calling that port. So I couldn't see Mr. Tsatsas' reasoning. The ship should have called that port, and there was a deadline for me to maintain, and that was why I was pushing him to get on with it.
So far from saying to Mr. Satsas that you could not give the confirmation, you were ultimately cornered into a position where you did give that very confirmation, didn't you?
No, I never gave him a confirmation.
And if we look at email 5, this is an email, this is a recap of your conversation, isn't it?
It's not a recap of the conversation. It's a message that Mr. Tsatsas sent after our conversation. I was not in agreement with that.
With your 30 years of experience, do you understand what a recap is?
Yes, definitely.
So when people are discussing, they've come to an agreement, one party sends it to the other, and if it's incorrect or in any way inaccurate, the other party responds immediately saying, no, that's wrong. That's correct, isn't it?
That's depending. If you are in commercial negotiations, it's being done like that. In operations, it's sometimes different.
So, and if we look at this email, he refers to your email exchanges and the recent conversation, and he expresses gratitude for your confirmation that you will hold the owners harmless for any loss or damage that the vessel may sustain as a result of complying with the charterer's orders. Do you see that?
Yes?
And you never responded to this, did you?
No, I didn't.
And the reason you didn't respond to that is because what he was there recording was correct.
No, that was not the reason. The reason I did not respond was the fact that I never made an agreement with him, and I never gave him guarantees.
Well, then if somebody says you've had an agreement, then the natural thing to do is to say, what are you talking about? You must have been in a different conversation because I never promised that. But you never did that, did you?
No, I didn't.
No. And I suggest to you that if there had been no such agreement, you, with your wealth of experience, would have immediately responded saying, look, Mr. Satsas, that's not what we agreed. If you think we agreed that, you're very much mistaken.
Well, I didn't respond because it was simply not reflecting our conversation, neither an agreement that we must have had.
And the only explanation for your lack of response is that it accurately reflected the agreement that you entered into with Mr. Satsas on the 25th.
That's not my statement.
No further questions, gentlemen.
My old head of chambers, gentlemen, said never re-examine. So I am going to re-examine. Mr. Van Blanken, it was put to you by Mr. Currier a moment ago that the message at page 5, if you just turn that up, please. That the message at page 5 was, in effect, a recap of an agreement that you had reached with Mr. Satsas over the telephone. Looking at this message, when you received it, did you interpret it as a recap, or did you view it in some other way?
No, definitely not as a recap, because it was not what we had agreed, and that's why I did not respond, because it was not a recap of our conversation.
So how did you view it?
I read it as a sort of statement that Mr. Tsatsas was seeking for a guarantee, and I couldn't give that to him. I have told him that in numerous occasions.
Thank you very much. Gentlemen, I have nothing further.
Thank you.
Gentlemen, we're going to launch straight into closings. If it assists, I shall be following the outline of my skeleton argument. And as I had previously intimated, there are 3 issues before you, gentlemen. Firstly, whether or not, firstly, whether or not the port was unsafe and the berth was unsafe and hence in breach of the charter party. Secondly, whether that breach caused the losses that have been claimed. And thirdly, quite apart from that, whether there was the hold harmless agreement that we've been exploring with the witnesses, which would cover the damage that is now being claimed. So I will take each in turn. I'm at page 2 of my skeleton argument. The law is generally not in dispute. There are some intricacies that we do need to look at, but generally the law is not in dispute. A safe port is a port which the vessel can get laden as she is and at which she can lie and discharge always afloat. That's Hall and Paul. We will be reverting to that case. The importance, and in fact we might as well look at that case now, and that appears in the authorities bundle, tab 1. So that's a tab 6, little tab 1. This was a case where the vessel was laden and then ordered to King's Lynn. Now, my learned friend seeks to distinguish that on the basis that the order was given after the vessel had already been laden. And in my submission, that makes no difference because the warranty of seaworthy, the warranty of safety is a warranty applicable to the vessel as she happens to be laden when she arrives there and as she is contemplated. In this case, she was contemplated to be laden up to 30 feet of fresh water. She was laden up to 30 feet, but just below. And that was in accordance with the charterer's orders. And so there was a warranty that the port would be safe for a vessel so laden. Now, the principles you get from this case, and this was a case where, if I could ask you, gentlemen, to turn to the third page, which is page 386, the argument was made that the master was stopped from alleging that the port was unsafe because he agreed to go to King's Lynn, even when he should have known that the vessel as laden could not enter King's Lynn. And in the top of the page, Mr. Justice Sankey says, as to the first of these points, namely that the plaintiffs were stopped by the action of their master from asserting that King's Lynn was not a safe port, I'm unable to accept the defendant's contention. It will be observed that King's Lynn was not inserted either in the charter party or in the bill of lading as the port of discharge. It was the duty of the defendant on arrival of the vessel at Tenerife to order her to proceed for discharge to a safe port or so near thereto as she could safely get, always afloat. And then when one looks at the relevant test, that's at the next page, between the two hole punches, the second full paragraph, that brings me to the final point. Was King's Lynn a safe port within the meaning of the charter party? In my view, it was not. A safe port means a port to which a vessel can get laden as she is and at which she can lie and discharge always afloat. And that is the test that has always been applied, and that is the applicable test. And if any further authority were required, one can see that in the next case, a decision of Mr. Justice Roche at tab 2 in Brostrom and Sons versus Dreyfus. And again, the relevant passage is in the second column of the second page, right at the bottom. Do you have that, gentlemen? It starts with the authority for that is Smith and Dart. Do you have that? If some more recent authorities be required, for the almost self-evident proposition is to be found in the case of Palace Shipping Company and Gans Steamship Line. The test of whether a port is safe in the physical sense or in the political sense is whether it is safe for the particular ship, laden as it is contemplated she will be laden, and as she is in fact laden under the particular contract of carriage in question, to enter and load or unload the port in question. Thus, a port is unsafe if a vessel cannot proceed to it and lie in it without lightening. That was laid down as long ago as 1881 in the case of the Alhambra. You see that, gentlemen? So that, in short, is the main issue that we will be looking at. Now, looking firstly at the port itself, I think there's a degree of common ground but my learned friend will correct me if I'm wrong, that the port was unsafe for this vessel as she was laden. Indeed, the port was unsafe in a number of respects, and I've set them out in page 3 of my skeleton argument, gentlemen. Firstly, there was a defective system for setting maximum permissible drafts. The Port Authority, the evidence is clear, was more concerned with maximizing its profits than the safety of the ships or of their crew or the environment. That is why it punished pilots who, in the bona fide exercise of their professional judgment and in compliance with the duty of care that they owe to the ship and the crew, advised ships not to come in or advised the master to avoid coming in. So you have a question?
Do you have any evidence that the pilots were put under pressure?
Well, indeed, yes, we have that in the, if we look at paragraph 49 of the agreed facts, we see that there had been other groundings, and halfway down paragraph 49, there was tension between the pilots and the Port Authority in that if a pilot refused to bring a vessel in without justifiable cause or advised a master not to bring in a vessel in, he risked having his license revoked.
From where does that information come?
Well, that information has been agreed between the parties.
That's agreed.
That is agreed. These are the common facts. So,
If I can clarify, so it's important to tread with caution. These are agreed facts, but of course what has been agreed here is simply that there was tension between the pilots and the Port Authority in that if a pilot refused to bring a vessel in without justifiable cause,
That was my question.
or advised a master not to bring a vessel in, he risked having his license revoked. So what was happening here?
If it's justified, then there should be no problem.
Who decides? What was happening here is, why do you have a pilot? If the Port Authority knows everything, why have a pilot? The reason you have a pilot is because he is a professional who exercises his expertise on the ground. And what the Harbour Authority was doing was subjecting that professional judgment to their overriding commercial consideration for making profit.
Well, were they saying that they were being overly cautious then? Unnecessarily cautious?
Well, it's not clear what they were saying, but either a pilot is up to the job or he isn't. Now, if you think the pilot's not up to the job, that's a different issue. But if you're saying the pilot is being cautious when it's not in your interest for him to be cautious, and hence you're going to deprive him of his livelihood, that to me, in my respectful submission, is putting the safety of the ship and the crew and the environment below the profit motive of the harbour.
Thank you.
That's what was happening. And and I suggest to you it's common sense that a pilot facing the prospect of losing his license is going to err on the side of taking her in. If a pilot's of 60-40, saying, well, 60%, given my own choice, I would not have gone in. I'm not happy about going in, but, I might lose my job. Let's just go in. Now, that in itself is unsafe. Even if on that particular occasion it happens to be safe, it is unsafe to restrict and subvert the professional judgment of the pilot in that way. It's, I think, common ground, the permissible draft of 30 feet that was advertised was unsafe. That's my learned friend's primary argument. There was no minimum under keel clearance policy. It only came in after the event.
Okay, thank you.
Yeah, sorry.
Can I just, again, clarify, gentlemen? My position is, as I hope is clear from our skeleton argument, that with an adequate underkill clearance, which is the province of the master, with adequate and appropriate allowance for squat, again, the province of the master, then this port would have been safe. A fortiori if the vessel had been loaded to a sensible draft. So this is not a question, just so that it's clear between my learned friend and myself, this is not a question of the port being unsafe come what may. This is a question of the port being safe, but being rendered unsafe in the particular circumstances by virtue of the conduct of the master.
Yeah.
While we're on the subject, excuse me for interrupting again.
Not at all.
But do we know what the speed of the current in the river would be during periods of non-rain, so to speak?
Well, all we know that well, no, we don't.
We don't.
We don't. But just, my learned friend will obviously have his time to make his case. But just to make it clear, my learned friend, as I understand it, and if he isn't, then he will say so when he comes to his go, is accepting that a 30-foot permissible draft was incorrect. It was unsafe for any vessel with a 30-foot draft to use this river. But yet, that was the maximum permissible draft of this port. Squat. Now, much criticism will no doubt be...
Before instead of squat,
Yes.
could I ask you a question on the agreed facts, and because it's relevant on the squat issue?
Yes.
In 19, paragraph 19 of the agreed fact,
Yes.
there's a statement in the second sentence. The chart showed that the river has a wide bay at its mouth, but when proceeding upstream, the river narrows considerably. And then there's this last statement, and there is a strong current from that point up to buoy number 7. Is that last part there, and there is a strong current from that point up to buoy number 7, is that something that is depicted on the chart? Is that what this sentence is intended to say?
So that's the way I would read it. But it doesn't give you a specific speed. But we know that it was six knots on this occasion.
On this occasion.
On this occasion.
I mean, so just on that, if it helps, I think I would agree with my learned friend that it would have been, if that's what he's saying, it would have been apparent from the chart, because a prudent master looking at the chart would see that there is an existing current. There would always be in a river. If the river narrows upstream, ergo, as a matter of common sense, that current will increase.
Yeah, but that wasn't my question. My question was whether there was an express statement on the chart.
I understand. We don't know the answer to that.
Okay.
Yes. And it would be helpful if my learned friend restricted his submissions to when it's his turn. Squat.
Sorry, I switched off at halfway through that sentence.
Squat. Much criticism will be made of the master that he ignored squat. But the bigger story here is the port ignored squat. I mean, the harbour authority, this was their port. They knew precisely what speed the water was coming down. They knew what effect squat would have. Yet what they were advertising is an arrival draft of 30 feet of fresh water. So it was clearly unsafe on that basis. There was an absence of lightning facilities. We saw the authorities, Brostrom, stating that a port that doesn't have lightning facilities is unsafe. And then we have the rapidly changing depths. We have in buoy 7 an additional issue making it unsafe, and that's the presence of underwater obstructions. Now, my learned friend says, oh, well, we knew there were underwater obstructions, so, that isn't a problem. The problem is they're uncharted. We don't know where they are. Simply knowing that there may be some somewhere doesn't actually get you home. Now, my learned friend's argument with regard to pre-arrival negligence by the master, in my submission, are fundamentally misconceived for a number of reasons. First and foremost, it stands the law on its head. What the law requires is, and provides, is that a warranty of safety is a statement and a promise by the charterers to the owners that your vessel, as laden, when she comes to this port, will be safe. And so it's the obligation of the charterers to make sure that the port is safe for the vessel as she is laden, not for the owners to load her so as she can navigate that particular port. That is fundamental, and you see that in the passages that I took you to in Hall and Paul and in the Brostrom case. And if you want to ask yourselves, how was it contemplated that the vessel would be laden, one only needs to look at the voyage instructions. And the voyage instructions are a full and complete cargo of 21,400. Now, we'll get into who has the discretion or the election plus or minus 10%. But when we look at the figures that my learned friend has suggested as to the underwater clearance, under-keel clearance, and the squat effect, there is no evidence to suggest that even if the master had gone to the lower end of that bracket, that it would have made any difference as regards this uncharted, unknown obstruction. So what is the instruction? She is contemplated, when you read the voyage instruction fairly, to come to port with a full and complete cargo with a freshwater draft of no more than 30. And that's what she did. So that's what they promised this port would be safe for. That if the vessel comes in below 30 feet, this port will be safe. That is the content of their promise, and it was breached. Secondly, my learned friend's argument confuses the charterer's rights and responsibilities with the owner's obligations regarding navigation. It is the charterers who decide how to employ the vessel. They are the ones who decide how much cargo to put on, if any. So my learned friends to say, well, actually, it was the owners who decided how much cargo to put on, and we did it. In fact, gentlemen, you will know the reality is quite the reverse. It's the charterers who decide how much cargo to put in. They retain the stevedores who put that in. The master has an overriding right to control that loading if it affects the safety of the ship. And we know from the authorities that he owes no duty to exercise that overriding right, from the cases of the Imvros, the Aconcagua, and of course the Courtline case. So, and we can see that from the charter party itself, because when one looks at the NYPE form, which is at tab 5, gentlemen, and on the third page, you will see at clause 8, line 103, gentlemen, and the charterer shall perform all cargo handling, including but not limited to loading, stowing, trimming, lashing, securing, dunnaging, unlashing, discharging, and tallying at their risk and expense under the supervision of the master. As I understand it, the New York law has a concept called borrowed servants. So even where the owners and the crew are doing all of this, it doesn't matter. They are the borrowed servants of the charterers. It's the charterers who are loading. So it was the charterer's own voyage orders that assured the master that a draft of up to 30 feet would be permissible and safe. Indeed, the charterers themselves did the loading, as we can see from the NYPE clause. And it would have been the charterers who determined where within the plus or minus 10% tolerance level the vessel was loaded. Furthermore, what my learned friend is really saying, and you'll see this further on when it comes to post-arrival, is, well, you shouldn't have obeyed our orders. Well, it really isn't, it doesn't lie in his mouth to say we shouldn't have obeyed his orders. We're required to obey his orders, and we owe him no duty not to obey them where they may be unsafe. So under those circumstances, we say the master owed no duty, and it was the owners, the charterers themselves, who actually loaded the vessel. Thirdly, it was for the charterers, once the vessel got there, to deal with the situation as it then arose. Mr. Buchan certainly would be aware of the decision in the Avian number 2, as will perhaps all three of you gentlemen. And you will know that there is an obligation to nominate a port that is prospectively safe, but then if circumstances change, there is a second obligation to change that nomination or to otherwise do something so that the port remains safe for that vessel. So to the extent that there were difficulties, it was for the charterers to resolve, and the way they should have done it and could have done it is by lightening. Indeed, if you look at the voyage instructions, you will see that it expressly states that the port authority will arrange lighterage to the prevailing draft at their expense. If it was determined, and my learned friend says it was quite obvious, that the prevailing draft, i.e. the safe draft, was less than 30 feet of fresh water, then there the charterers had promised to lighten. But as Mr. Van Blanken told you, he refused to lighten. Now, in my submission, Brostrom and Dreyfus applies directly to the present case. In that case, the charterers ordered the vessel to discharge at Londonderry even though she was too large to enter without tug assistance, and no tug assistance was available at Londonderry. Similar to lightning here. She needed lightning, there was no lightning. In Brostrom, she needed tug assistance, there was no tug assistance. The court held that even though Londonderry was safe for 99 out of 100 ships, or even a larger proportion, it was not safe for this vessel as she was when she came to the port. And therefore, it was up to the charterers to order tug assistance all the way from the Clyde in order to make the port safe for that vessel. Fourth, and I think this is, as you will see from Hall and Paul, the port was unsafe because you could not proceed safely to Buoy 7 without lightning, and there were no lightning facilities. Fifth, it was reasonable when we're looking at the post-arrival situation for the master to obey the orders, accept the reassurances given not only by Mr. Van Blanken and the charterers, but by the port authorities and the pilot. And it really, what my learned friend is saying is, when we, the charterers, told you that this port was safe, you should not have believed us. Well, it doesn't lie in his mouth to say that. When the harbor authority told you it was safe and gave you a letter to that effect, you shouldn't have believed them. When the pilot said it was safe, you shouldn't have believed him. And there's authority directly on this point, and this is at the tab 3 of the authorities bundle, gentlemen. This is the recent decision of Mr. Justice Tier in the Ocean Victory. And if I could ask you, gentlemen, to go to page 82, paragraph 121. Here, Mr. Justice Tier deals with the famous decision of Mr. Justice Devlin in the Stork. If I could ask you to read on the left-hand column from the middle of the page. What was suggested here is that the master should not have complied with the advice of local mariners. And Mr. Justice Tier says, it is unrealistic to expect the master to ignore such advice when it comes from a local experienced mariner. Captain Gaines said that the decision whether or not it would be safe to stay would be a question of local knowledge. The importance of local advice and reliance reasonably placed upon it by mariners visiting a port have long been recognized in the context of safe port warranties. Thus, in the Stork, the question of whether the master voluntarily assumed the risk of entering Tommy's Arm when he himself judged it to be a very dangerous place. And Mr. Justice Devlin said, it is peculiarly a case in which a master, whatever his own feelings, might think it wise to defer to those with local experience. And again, in the Court of Appeal, they came to the same conclusion. And that's what the master did here. So master was reasonable and entitled to follow the guidance and indeed the express orders of the charterers, and was not negligent in that regard. Finally, as regards unsafety, we say the charterers, having warranted the safety of the port and the buoy, refused to lighten the vessel despite our pleas that they do so, and repeatedly reassured the owners that the port and the berth was safe and that the vessel should proceed upriver, cannot now say that it was somehow all due to the master's negligence. Causation. I think it's is or should be common ground that but for the novus actus argument, the unsafety caused the loss, and I don't understand it to be argued otherwise. As far as whether the master's error broke the chain of causation, the error was his mistake in calculating squat based upon the speed of the vessel over the ground as opposed to her speed through the water. Now, what is the legal test? I'm at page 8, paragraph 30. The legal test has been established authoritatively in the Court of Appeal that it requires obliteration. I've quoted it in paragraph 30, but gentlemen, if you need to see the authority itself, it's at tab 6. It's the decision of the Court of Appeal in Flanagan versus Greenbanks. And in order to obliterate the pre-existing cause, here the unsafety, the master's conduct would have to be reckless or near to it. In my submission, the master's conduct is not reckless. And it lies ill in the mouths of the charterers who were encouraging him to go upriver to say that it was. He complied with the letter of authorization issued to him by the Harbour Authority. The charterers assured him it was safe to go up, as did the pilot. So he was negligent in the way he calculated squat, but that does not obliterate as a cooperating cause the unsafety of the port. And again, the pilot made the same mistake, and the port made the same mistake over a period of years, because they never took squat into account when setting their permissible draft limit. Finally, the hold harmless letter, the hold harmless agreement. You gentlemen have heard the two witnesses. In my submission, it is clear that there was an impasse between the charterers and the owners. The owners could afford to wait. The charterers could not. The charterers were desperate, and Mr. Van Blanken accepted as much, to have the vessel starting to discharge by the 30th of June. You heard Mr. Satsas, he was not willing to budge. What he wanted the charterers to do was lighten. Mr. Van Blanken explained that that was a no-go, simply because it would take too long to bring in lightning facilities. So where did they end up? They ended up with Mr. Satsas saying, well, if you're not going to lighten, you have to hold the owners harmless for anything that happens. And forced into the corner as he was, Mr. Van Blanken, who at that time did not know about the previous grounding, believing the port to be safe, gave that undertaking. And if you want to look at the contemporary documentation, you've got email 5, which is only consistent with such an undertaking having been given. And the failure of Mr. Van Blanken when receiving that email to argue or get back and say, well, this is an error, I never agreed any such thing, speaks volumes. Unless I can assist you further, gentlemen, those are my submissions.
Thank you.
Gentlemen, I'll also follow, if you're content, the broad structure of our written opening. My learned friend is right to say that certainly as regards the test for port safety, there is not, in truth, a great deal between us. But there is, as will have emerged already, something between us, certainly with respect to the role of the owners and any responsibility which they have with regard to loading the vessel to a safe draft before she proceeds on the voyage. Now, I would be the first to accept that in circumstances where the vessel is already laden in accordance with whatever instructions a charterer gives, prior to the voyage instructions being given to proceed to a particular discharge port, in those circumstances and in the premises of a safety warranty, it goes without saying that that discharge port must be safe for the vessel in that laden condition. Because, of course, that's in a situation in which it is beyond the control of anyone, unless you implement some form of lightning, to affect the vessel's draft. And it's for that reason that we see the authorities that my learned friend took you to, which illustrate that if you're dealing with that sort of scenario, then it's for the charterers to bear the cost of lightning in order, as it were, to remedy what is by that stage their breach of the safety warranty. Ours is a very different case, and if you look at, if we start just by going back to Hall Brothers, and that's the first of the authorities in the authorities clip at tab 6. What you will see, gentlemen, if I can invite you, please, just to take up the first page of that decision. I'll give you a moment to turn it up. Just reading toward the bottom of the page, you'll see the words there, action tried before Sankey J without a jury. And there is an important summary of what the factual position was, which gave rise to this decision. The plaintiffs, as owners of the steamer Peerless, claimed the sum of, these were the days, £48, 12 shillings and 9 pence. against the defendants as receivers of a cargo of maize shipped at Rosario and San Nicolas on the said vessel under a bill of lading dated December the 16th, 1913, incorporating the terms and conditions of a charter party dated November the 11th, 1913. By that charter party, the vessel was to call at Tenerife for orders to discharge at a safe port in the United Kingdom. So what that tells us, in terms of the factual premise which gave rise to the dispute and in due course the decision in Hall Brothers, was that the contractual position was vessel loaded a cargo of maize in South America at Rosario and San Nicolas, was required by the charter party to proceed to Tenerife for orders to discharge at a safe port. And it's after that, if you turn over the page, top of page 385, you'll see there the first clear paragraph, the Peerless duly called at Tenerife and received orders to discharge at King's Lynn. She proceeded on her voyage, but her draft was such that it was impossible for her at any time, on any tide, to enter the dock at King's Lynn. So this was a case where the vessel had loaded in South America. Pursuant to the charter party, she proceeded to Tenerife for orders. At Tenerife, the order had been given to discharge at King's Lynn. And as it turned out, the vessel's draft, laden as she was at the time that the order to discharge at King's Lynn was given, was too deeply drafted safely to get in. As a consequence of that, she could only get in if she lightened, and Mr. Justice Sankey held that means that King's Lynn is not a safe port, if and to the extent that the vessel must lighten, that's for the charterers to bear the cost. Now, ours is a case, and I think made this abundantly clear, where at the time that the orders in this case were given to proceed to buoy number 7 and to the discharge port with which we're concerned, loading hadn't even started because the voyage instructions, this is an important clarification, this of course is a time charter trip, so this is a time charter context, it's not a contract of carriage, it's not even a contract for carriage, this is a contract for services. So at the time that the voyage instructions are given, the master learns for the first time not only where he's going to discharge, but where he's going to load. And so in these circumstances, the master is presented with a situation in which, under a time charter, he's told, this is where you're going to load, this is where you're going to discharge. There is an option as to how much cargo to load. And the question is, whose option was that? My submission is plain and simple. It was obviously the owner's option. And that's for two reasons. One is because we are told in the statement of facts that it was the owners who instructed the vessel to load as much cargo as she did. It's the owners who loaded it. And the second point is that there is no evidence of any further instruction from the charterers beyond those voyage instructions to which we see reference in the statement of facts. So it can't have been the charterers who said, load to this draft or load this much cargo, because there's no evidence that the charterers gave any instructions above and beyond the limited instructions that you see.
Can I ask you a question about the instructions? Or
of course,
would you
sir.
prefer that you finish your argument?
No, not at all, sir. I'm happy to take it now.
In the instructions, the last sentence of the quoted instructions is, in the event that the draft of the river is below 30 feet fresh water,
Yes.
the Port Authority will arrange lighterage to the prevailing draft at their expense.
Yes.
And my question is, in your view, in the charterer's view, what reliance could be placed by the owner in deciding on the intake on that statement?
Well, there are 2 points there, sir. The first is that what that demonstrates, if one reads that final sentence with the final words of the preceding sentence, vessel's arrival draft not to exceed 30 feet fresh water. First of all, the owners and the master know that it's not being said load to 30 feet. Bang on, no less, no more. What's being said is you can load up to 30 feet. But ultimately, it's in your discretion as to the draft to which you do load. You can load to less than 30 feet if you want to. Second point is that what the final sentence tells you is that the draft in the river is almost by definition inherently unpredictable. And therefore, it may well be necessary that the vessel will have to lighten depending on what the position is when she gets there. What it does tell you is that to the extent that any lighterage is necessary, it's the port authority who will arrange it, not the charterers. My learned friend said, oh, well, charterer's responsibility, it says it in black and white. It doesn't say that. It says it's that the port authority will arrange lighterage to the prevailing draft at their expense. So what this does is it gives the owners, in my submission, no platform upon which they can rely in order to say, well, we can load willy-nilly to any particular draft within an available range, because when we get there, if we're overdraft, then there would be lightering in any event. And that's really one of the fundamental problems for my learned friend. If you distill my learned friend's case into a single proposition, and this is a feature of his case which emerges at every turn, it is in essence that the owners had absolute, unqualified carte blanche to load this vessel to any draft they pleased, even if they and the master knew full well, on the basis of the available factual material from the charts, from the pilot and so on, even if they knew full well that she would ground when she got to the discharge port.
But just to go back to this particular sentence, it's your submission then that this sentence as drafted was not something that the master could put any reliance on. It was merely a warning to the master. Is that what you're saying this wording does? It merely warns the master? It doesn't give him any basis for reliance as to what would happen if the river was in fact below 30 feet fresh water.
What it does is it puts the master on notice of the fact that the available depth of water in the river is unreliable. And it puts the master on notice of the fact that the one thing he shouldn't do is to load to more than 30 feet. And if he loads to more than 30 feet, then he's overplayed his hand anyway. If he loads to 30 feet and it turns out that in fact lighterage is necessary because of the prevailing conditions at the time of arrival, then the port authority will undertake lightening. But what that doesn't do is to affect the scope of his liberty, which is set out in the previous sentence. And what it certainly doesn't do in my submission is to give the owners a license to say, we will just load to a draft which any prudent master, if any prudent master standing on the master's shoulder might say, look, you've got a chart that tells you that the maximum available water is 9.1 meters. And you've got an Admiralty pilot that tells you that the depth of water in this river is very variable, very unreliable, and what you have to do is check, before you do anything, and certainly before you enter the river, is to check with the local authorities as to what the available draft is, as to what the available water depth is. So that's what a master knows at the time that he decides what quantity to load. Imagine, therefore, gentlemen, our master with a prudent master standing right behind him. And that prudent master would say, okay, chart tells you 9.1 meters maximum draft, maximum water. Admiralty pilot says be careful. Remember, you need to allow for underkeel clearance as a matter of prudent passage planning on any view. And remember, you need to allow for squat. And this is a river, so you need to allow for the fact that there will be a fairly strong current. And you also need to allow for the fact that the river narrows as your passage increases. So the squat, you need to allow an even greater allowance for squat. So make sure that you do all of those things, and a prudent master will weigh all of that in the balance when deciding how much cargo to load. What does our master do? None of it. But on my learned friend's case, not a problem. He can do that with total impunity and lay the bill at the charterer's door simply because in those voyage instructions it says not to exceed 30 feet fresh water. So in my learned friend's case, the owners and the master can abrogate themselves entirely of any responsibility to assess an appropriate draft for this ship and hand the bill to the charterers. And in my submission, that's a nonsense. And it's certainly not what the authorities say. And my learned friend seeks to derive some further assistance in that regard from the decision in Broster and Dreyfus. And again, if you briefly look at that, that's in the second of the tabs. Now, that again, gentlemen, it's a very different case on the facts. That's a case of a vessel of specific fixed dimensions being ordered to proceed to Londonderry. Now, nothing in that factual scenario is ever going to change. The vessel's dimensions won't change, and nor will Londonderry. Therefore, if Londonderry is too small for this vessel safely to enter, and Londonderry doesn't have adequate supply in terms of tug assistance, then by definition, it's going to be unsafe for that vessel. So there's nothing novel in that. But what is interesting is the way in which Mr. Justice Roche formulates the test. And he says, again, if you look at the bottom of the right-hand column at page 137, just to reiterate, he says the test of whether a report is safe in the physical sense or in the political sense is whether it's safe for the particular ship, and then open brackets, laden as it is contemplated that she will be laden, and as she is in fact laden under the particular contract of carriage in question. Now, we're not concerned, as I said a moment ago, with a contract of carriage. We're concerned with a contract for services. So, again, ours is a very different sort of case, but what is interesting is that what Mr. Justice Roche is referring to is safety assessed by reference to the vessel laden as it is contemplated that she will be laden. And to come back to the point I was making a moment ago about the proposition on which my learned friend's case stands, the singular proposition, the owners can do whatever they like and just hand the bill to the charterers. Who, in their right mind, as a prudent owner, would contemplate that this vessel, in our case, would proceed at a laden draft, which a prudent mariner standing behind our master would say, you can't possibly proceed at that draft. You've made no allowance for squat, or such allowance as you've made is wrong in principle and wrong in amount. You've made no allowance for underkill clearance, and you're proposing to load to a draft, which by definition gives you a freshwater arrival draft, which is more than the chart says the port can accommodate. Who on earth would contemplate somebody loading to that level? Nobody would. So taking Mr. Justice Roche's test, was the port, in this case, was the discharge port safe for the vessel laden as she would have been contemplated to be laden? Yes, because the way in which she would be contemplated to be laden by anybody with a measure of prudence is to a draft which doesn't exceed the maximum water stated in the chart, to a draft which allows for underkill clearance, and to a draft which allows for squat. The master here did none of that. But my learned friend says, not a problem. Charterers must pay. Now, gentlemen, that, in my respectful submission, is an extraordinary proposition, and it isn't one which, in fact, is borne out by the authorities. If I turn against that background back to the points which we've made in our written submissions, I've made a number of submissions in paragraph 17, which I don't need to reiterate in any great detail. But there are one or two elements of that which are just worth highlighting. Squat. The evidence, such as it emerged from the formal inquiry in the United States, was that on any view, a prudent mariner would have allowed something between 6 inches and 24 inches for squat for the purposes of navigating in this river. Now, in my submission, in cases of doubt, do you do 6 or do you do 24 or something in between? a prudent mariner would err on the side of caution and would say, I'll go for 24, thank you. If this vessel had been at a draft which was 24 inches less than she actually was, there is simply no question of whether she would in fact have grounded. Simply by making that allowance, 24 inches, she would have missed the 29-foot soundings of which complaint is made, and she would have missed the obstructions to which the pilot referred.
Perhaps my learned friend can point you to the evidence that shows at what depth those obstructions were.
They were at 31 feet. They were stated to be at 31 feet.
Certainly was my understanding that.
So you had obstructions at 31 feet, and then you had 29-foot soundings. So if she was going to hit anything, she'd hit the 29-foot soundings because the obstructions are 2 feet lower. If you've got an extra 2 feet of draft to spare because you're allowing 24 inches for squat, you're going to miss all of this. A fortiori if you make a proper allowance for underkeel clearance. So these are simply points which, as it were, emphasize our submission that this was a port which was not unsafe in principle for this vessel. It was only unsafe because the master created the unsafety in the first instance and then exacerbated that by electing to proceed at such a draft in circumstances where no prudent mariner would ever have done so. And in paragraph 17.3, I've actually set out, just in order to illustrate the point, some calculations which bear all of this out. You've seen those, gentlemen. I won't take you through them again now. Now, my learned friend says, well, as it were, be that as it may, we have a situation in which the master was entitled either to rely upon any assurances he was given by the charterers or to rely upon what he was told by the pilot locally. Now, and in that regard, you'll recall my learned friend took you to Mr. Justice Tear's decision in the Ocean Victory on the latter point. Now, all of that is an irrelevance because against the background of what I've already submitted, gentlemen, this is not a case of a prudent master coming a cropper on the basis of reliance upon the peculiar, nuanced, but mistaken knowledge or assumptions of a local pilot. This is a master coming a cropper because he has made some fundamental errors in prudent passage planning. If the master had not, as it were, drifted into those errors, this casualty would not have occurred, irrespective of what he was or wasn't told by the local pilot. So this isn't a case of a pilot, for example, saying, you're at a perfectly adequate draft, you've made a perfect allowance for underkeel clearance and squat. I know that you might be concerned that even with all of those allowances in place, we might ground, but trust me, this is my turf, I know it well, if we follow this track, you'll be okay. That isn't what the pilot is saying here. The pilot is simply saying, there are some obstructions, uncharted they may be, but I know where they are, and I know how deep they are, and the rough draft, or the rough available water, here is this, there is that. Let's go through. So all that the pilot is doing is giving the master some elements of fact. But it's the master who ultimately retains the responsibility of saying, with all of that information, and assuming that I've done my job properly, and he hadn't, is it safe to proceed? Or should I simply put the brakes on and say, I'm not going any further, it is not safe? And this is a case where a prudent master, in my submission, would have said, I'm not going any further. I'm grateful, Mr. Pilot, for your local knowledge, but I don't feel comfortable with this. But the master threw caution to the wind in this case, and he threw caution to the wind for one reason. He himself had made such brazen and fundamental errors with his approach to prudent passage planning, he wasn't aware that, as it were, he was about to assume a risk which no prudent mariner would assume. He thought he was assuming a risk which didn't exist. But the risk did exist, and a prudent mariner would have known that. So that's, as it were, the difficulty which my learned friend faces. And it's wrong for my learned friend to seek refuge in a number of authorities which aren't cited in his skeleton and haven't found their way into the bundle. For example, Courtline and the Imvros and so on. Those, just so that it's clear, gentlemen, and you'll be familiar with them, those are all authorities which are concerned with the extent to which a master is obliged to intervene in the loading of a vessel in circumstances where it might give rise to a risk of unseaworthiness. Now, the important word there is intervene. They are concerned with a situation in which a master, whether or not a master has an obligation to step in to an operation which is already the charterer's responsibility. That's not our case. It's the master's responsibility to fix a safe draft on the facts of this case. So they're irrelevant. So, gentlemen, in all of those circumstances, our submission is, particularly if you view all of this against the background of the fact that this was a charter party which incorporated the US Carriage of Goods by Sea Act. So all questions of prudence and everything else have to be adjudged against the possible tension between charterer's voyage instructions and the fact that the master has an obligation to ensure that his vessel is seaworthy. My submission is no prudent master would set to sea in circumstances such as these, knowing, as he should have done, that if he goes at that draft and he elects to load to that draft, he will ground. And a fortiori, it cannot possibly be right to say that as a matter of principle, he can do that, and then at the end of it all say, oh dear, my vessel is grounded, resulting in millions of dollars worth of damage and liability. Here's the bill. It's a nonsense. So, gentlemen, that brings me then to consider the question of the issue of causation. My learned friend is right to say, I think there's nothing between us on the authorities. The principle is...
So before causation...
Yes, sir.
Mr. Tsatsis, in his evidence, and this goes to the issue of whether, particularly on what you say is exacerbating the master's alleged inadequacies.
Yes.
Before we go to the issue of causation, the question arises as to the master's failure to calculate issues like squat. And Mr. Tsatsis in his evidence referred to a distinction between available and permissible draft.
Yes.
And that he assumed, and I assumed therefore that from his discussions with the master that the assumption was being made by the owner that the permissible draft that had been set down by the port authority and which was being stated to be applicable by the pilots included within it an allowance of factors like squat. And
Yes.
my question is, to what extent in your view, the master could reasonably rely on such an assumption?
Well, so one can almost short-circuit that question by virtue of the fact that it doesn't appear that the master did understand it in that way, because he was at a draft which, on any view, didn't include any allowance for squat or underkeel clearance. So even if he was proceeding on an assumption that the, let's call it the advertised draft, was one which, as it were, incorporated an allowance for squat and underkeel clearance, that was something which he had simply ridden roughshod over in any event. So whether or not, as it were, objectively, it stands to be understood as incorporating an allowance for squat and underkeel clearance, that wasn't something which, as it were, he'd actually implemented in any event. So, gentlemen, as far as causation is concerned, my learned friend is right, I think, to say that the relevant test is whether the intervening cause obliterates, as it were, any residual effect, if there is any residual effect, of the primary cause. And our submissions are set out in some detail in the written document in that regard. We simply say, as a matter of fact, in this case, it is plain that the conduct of the master, in this case, obliterated any effect of any alleged breach of a safety warranty. As I've already submitted in my submission, such was the master's conduct. There was no breach of the safety warranty at all. But if there was, then it simply cannot be right to say that there was any remaining effect, any notional remaining effect of such a breach of the safety warranty by the time the master had concluded that he would proceed down to buoy number 7 in all of the circumstances. Because for the simple fact that a prudent master, equipped with all of the factual information available to our master, would not have proceeded. And that's the critical factor. And that is something which is amplified by the fact that if you read the observations of the Court of Appeal in Flanagan and Greenbanks, citing Mr. Justice Gross in the Borealis case, it said in terms, I quote, "The more the claimant has actual knowledge of the breach, of the dangerousness of the situation which has thus arisen, and of the need to take appropriate remedial measures, the greater the likelihood that the chain of causation will be broken." Well, the master plainly knew what the position was. A prudent master plainly knew what the position was here. So this wasn't a case of a master, as it were, necessarily proceeding in some sort of information vacuum where neither he nor anybody else could ever have known better. And nor was it a case of a master, as I say, being led up a garden path by virtue of the nuances of local knowledge of a pilot. The master had already trodden that path, and the pilot simply joined him there. And so, gentlemen, that just brings me to the question of whether there was, between Mr. Van Blanken and Mr. Satsas, some unqualified undertaking on the part of the charterers to pick up the bill, some sort of hold harmless agreement. And in my respectful submission, Mr. Satsas' evidence in that regard is unreliable and inherently inconsistent. Mr. Van Blanken is the one who was wholly unmoved with respect to whether there had actually been any unequivocal agreement in that regard. And in my submission, reading that final message, message number 5 from Mr. Satsas, it's quite clear in my submission that that is a document, as much as Mr. Satsas was reluctant to accept it, which, objectively interpreted, was a request for a hold harmless undertaking, not a recap of one that had already been agreed. That's why he says grateful for. He's not saying thank you very much for something we've already agreed. He's saying I would be grateful for, and that's the reason why, you may recall I explored with him in cross-examination, that's the reason why he makes express reference to what he perceives to be charterers' motivation for perhaps giving some sort of undertaking. If you've already got an undertaking in the bag and you're simply saying, here's a recap, you don't include some reference to what might be charterers' justification for what they've already agreed to. You simply say, this is what we've agreed. So reading that message objectively, it's clear in my submission that it was a request, and the evidence is unchallenged. He didn't get a response to that. So there's no agreement, and nothing could, as it were, be more emphatic in proof of that than the fact that at 3 o'clock in the morning, when the casualty occurs and Mr. Satsas calls Mr. Van Blanken, he makes no mention of the fact. He doesn't say, vessel's gone aground, it was only a few hours ago that you assured me it was absolutely safe and sound, and we have a hold harmless agreement. This is your problem. Not a mention of it. So, gentlemen, unless I can assist you further, those are my submissions.
Can I correct? Yeah, Mr. Phillips, your submissions do not deal with one factual issue, which I think is quite important, which is the pressure that your client seemed to have been under with respect to the 30th dateline. So it seems to stick out like a sore thumb that, that they were not talking about that at all. So could you just address that?
Well, I think Mr. Van Blanken was quite candid in his evidence in saying, yes, there was some pressure to get the cargo in by the 30th. There's no debate about that. The question, gentlemen, is whether on the back of that he was pushed or forced into agreeing to an undertaking in order, as it were, to bring that about. And my learned friend sought to make much of the fact that Mr. Van Blanken perceived there to be no real risk in the vessel proceeding. And it seemed to be suggested, so that's the reason why you would have given this undertaking. But of course the flip side is Mr. Van Blanken would say, as he did say, well, why would I need to give that undertaking? In my view, if the vessel is at no real risk of any damage, we already have a charter party between us, we have a contract, just get on and perform it. Yes, I'm under some pressure, but you're telling me that if I give a hold harmless agreement, you'll proceed, and if I don't give it, you won't. But in that situation, if you don't proceed and I need that cargo, and it is in fact safe to proceed, I will recover from you in any event, because then there will be a wholly wrongful refusal to proceed with my legitimate orders. So I'm not going to give you, as it were, consideration in the form of a hold harmless agreement for something which I say you already have consideration for. That's my undertaking to perform in accordance with the charter party.
That would then turn on the question of whether they were justified, isn't it? It's a question of the justification not to proceed because of the potential danger. So we'd still be grappling with a factual issue there.
I mean, there's no factual issue, sir, as to whether Mr. Van Blanken was under pressure to get his cargo, because he admitted to that fact. So the only question is whether that pressure, as it were, tipped the balance and caused him to agree to a hold harmless undertaking or not. Now, his evidence is absolutely unwavering. No, it didn't. Mr. Satzer's evidence, particularly against the background of that final message, in my submission, is wholly equivocal. And indeed, that final message is entirely consistent with Mr. Van Blanken's summary of the position. He's saying, look, I made it clear, I said we will perform in accordance with our obligations under the Charter Party. Yes, I want my cargo. No, I cannot give you any further assurances. And the way in which Mr. Van Blanken put it was, as you may recall in his evidence, if I will speak to my operations guys, if there's anything more to add, I will come back to you. And he never came back.
Gentlemen, firstly, what my learned friend seeks to get away from is what is the contract between the parties and what were the charterer's orders. If one looks at the NYPE form at tab 5, this is something which will be common knowledge to you gentlemen, but from line 102, the master shall be under the orders and directions of the charterers as regards employment and agency. That is trite. And the charterer shall perform all cargo handling, including but not limited to loading, stowage, trimming, lashing, securing, dunnaging, unlashing, discharging, and tallying at their risk and expense. So makes it very clear that the orders are given by the charterers, the master obeys those orders, and it's the charterers who load, and they do so at their risk. So what were their orders? If we go to paragraph 13, the orders were to load a full and complete cargo of 21,400 metric tons, plus or minus 10%. Now, who was doing the loading? It was the stevedores. Whose stevedores were they? They were the charterer's stevedores. They would have chosen whether to go minus 10% or plus 10%. In fact, we ended up about minus 1%. Furthermore, what is being said about the discharge port? What we're told is it's a safe berth at Port Lindsay where the vessel's arrival draft not to exceed 30 feet. So the master's being told you're okay to 30 feet. And his order is to make sure that the draft does not exceed 30 feet. And in the event, and this is the event that actually happened, in the event that the draft in the river is below 30 feet fresh water, the Port Authority will arrange lighterage at the prevailing draft at their expense. Now, that last part, as I state in paragraph 12 of my skeleton argument, has two effects. First of all, it tells you a characteristic of the port, which is a false statement. It tells you that the port is safe if the water doesn't allow a draft of 30 feet because the port itself provides lightening services. That's a false statement. It's not true. Port is unsafe as a result of that. Secondly, it's clear, these being the voyages given by the charterers, that the charterers are also saying that the Port Authority, acting as my agent, because of course it's the charterers who have to make the port suitable for the vessel, will organize the lightening. In any event, the master was entitled to read from this that I'm required to load up to 30 feet if there are any circumstances when I get there which prevent the vessel from going upriver, then she will be lightened. I've been told that in these voyage instructions. So it's clear that there was no reason why the master should concern himself about the issues that my learned friend said. He had to comply with these orders, and the charterers had assured him that the Port Authority would arrange lightening if required. Now, looking at the Brostrom case very briefly, it is important to note, and my learned friend commended Mr. Justice Roche's clever very precise formulation. He says that the test is whether a port is safe in a physical sense or in a political sense, is whether it is safe for the particular ship, open brackets, laden as it is contemplated that she will be laden, and you have my submissions on how she was contemplated to be laden, up to 30 feet fresh water. But then the learned judge goes on, and as she is in fact laden. And how was she in fact laden? Well, she was laden in accordance with those instructions, with 29 feet 11 inches of draft. And the promise was that the port of Lindsay and buoy 7 would be safe for the vessel as she was then laden. And that is the content of the warranty that is given. Now, what my learned friend has engaged in some expert evidence, but also doing some calculations in his skeleton argument. And he says 2 points which don't actually meet. First point, he says that the master had the option of loading 1,940 metric tons less. This is the 10% tolerance. Well, you have my submissions on that. That wasn't the master's election. But even if it were, does it get him home? Because what he says is you start off with the 30 feet of fresh water. You then take off 10% for under keel clearance. That gives you 27 feet. And then you take away 24 inches, which is the squat effect. That gives you 25 feet. There is no evidence and no suggestion that even if the master had loaded minus 10%, i.e. 1,940 metric tons less than the vessel actually did load, that she would have a freshwater draft of anything near 25 feet. So all this analysis doesn't actually get him home. The permissible draft and the available draft, that distinction is made in the voyage instructions themselves. What is said is that the permissible draft, you come here with 30 feet, you're okay. If there are any issues, you will be lightened. It wasn't okay, and they wasn't lightened. And that very distinction, the Harbour Authority understood their 30 feet advertised figure to be the permissible draft, arrival draft. Mr. Van Blanken, in his emails and in his evidence, understood that as long as you arrived with 30 feet of freshwater draft, you could go up the river, which everybody knew had a strong current. And Mr. Satsas explained in his evidence that that was his understanding as well. As far as causation is concerned, you've seen the authorities. What is required is recklessness on the part of the claimant, such that you can say the original cause, the unsafety of the port, has been obliterated, this is not this case. There is contributory negligence, that's fine. There are two cooperating causes, you could say, that's fine. All we need to show is that the unsafety of the port remained a cause of this casualty. And in my submission, it did. Finally, the hold harmless agreement. Well, gentlemen, you need to look at the inherent probabilities and indeed the evidence that the two witnesses have given. Firstly, and as was pointed out by Mr. Benny, the charterers, and Mr. Blanken was very candid about this, were under immense pressure to start discharge on the 30th of June. The owners were under no similar pressure. There was an impasse. I think both parties agree that. Who blinked? Who had the incentive to blink, and who had no reason to worry if he did blink? And in both of those cases, that's Mr. Van Blanken. He was under immense pressure to ensure that discharge started by the 30th of June. He, at that point, knew of no problems at all over the number of years that their vessels had used this port, and therefore he thought that this was a storm in a teacup. Mr. Satsas was getting excited for no reason. If what he had to do was to give an agreement to hold harmless, then yes, that's what he had to do. It didn't concern him much because he was convinced that the port was safe anyway. So, and trying to construe email number 5 as somehow a request, it clearly is no such thing. And in my submission, if you read it, you will conclude, gentlemen, that that is a recap. And a man of Mr. Van Blanken's experience in the shipping business would have responded to that recap and said, no, that is not what I've agreed, if that had been the case. So in my submission, you should find for the claimants in this case. Unless I can assist you further, those are my submissions.
I have one question.
Yes.
Going back to the voyage instructions, it says that the ship is going to discharge at 1 or 2 safe berths at Port Lindsay.
Yes.
And yet, in the first instance, she was ordered to a buoy. Now, was she going to lighten there?
Well, she was certainly going to discharge. The common facts are unclear whether that was the only discharge berth or not. But the point here is that the lightening was required at the bay before you went upriver. That's where the lightening was required. Whether you required further lightening as you went up is neither here nor there. What the instructions say is that if the draft in the river is below, then you will be lightened before you go up the river.
That's fine. Thank you very much.
Well, thank you very much, gentlemen. Thank you, Mr. Carrier. Thank you, Mr. Phillips. Now we're going to ask the arbitrators to retire to what is known as the green room. Unfortunately, there are no alcoholic drinks there, however. We've run a little bit over time, but we've got to give the arbitrators a reasonable time to think about things, so I think we're going to ask them to retire now. And we'll then, I'll just make one point about CPD points. Those of you who are lawyers are very keen on CPD points, even I am. You'll be pleased to see you get 5 CPD points for coming today. And you'll also have seen, coming up on the back there, your own views as to whether the owners and the charterers should be liable in this case. It's fairly heavily weighted against the charterers at present, but we're now going to close the poll, so if anybody else wants to press their buttons, please press them now. But otherwise, again, just thank you to everybody who's participated so far, and if you'd like to come back at 4:15, then we'll see what the arbitrator's decision is and whether they agree with you. Thank you. The tribunal have returned, and obviously the thing for me to do is to now invite them to tell you the decisions that they've come to, and bear in mind they will give an individual decision based on their domicile, if that's the right way of putting it. So over to the tribunal.
We thought that we should deal first with the hold harmless agreement or not. And we have reached a majority decision on that. Mr. Benny dissenting. So I will give the majority decision and the reasons. First, are we able to find that the charters had agreed to indemnify the owners for losses or liabilities incurred as a consequence of proceeding to buoy 7? And in the majority view, no. It would have been logical for Mr. Satzis to have sought such an agreement from Mr. Van Blanken. But in the circumstances, equally logical for Mr. Van Blanken to have refused to give it. The owners rely on the email from Mr. Satzis of 25 June, but that message is ambiguous. The second sentence starts, grateful for charter's confirmation, etc. And we have to agree with Mr. Phillips that that sounds to us more like a request for the charters to give an indemnity than a statement that the charters had already agreed to do so. So we are therefore not satisfied that the charters had so agreed. Now, Mr. Benny will give his thoughts.
I take the view that the letter of the 25th is open to interpretation, obviously, in two different ways. It's not clear to me on a plain reading of the document that it was a request. It could easily also have been interpreted as a confirmation of the discussion. But I therefore had to try and assess the evidence and look at the witnesses, their explanations, the demeanor of the witnesses, and due to some shifting of the eyes at some inappropriate moments, I think equally I tend to agree with the submissions of the owners that with the document of the 25th being so unclear, I think anyone in the position of Mr. Van Blanken, I think ought to and certainly should have, in my view, taken some position, should have protested, should have said something. And when I look at the explanations which were being given to us, I'm not convinced. And therefore, I'm of the view that an indemnity was in fact given, if nothing else, also because of the enormous pressure that the charters were under to actually discharge the vessel by the 30th. So I can see reasons why the charters would give such an indemnity, and I can see no compelling argument to make me think otherwise. So on that basis, I would find that an indemnity was in fact given.
Do you want to add anything? No. Well, I'll only, because I don't think we'll come back to the hold harmless again, I'll just mention, although English law is governing this charter party, if we were applying US law to this issue, I think I would be mindful of the fact that while there's not a statute of frauds requirement for a hold harmless to be in writing, and certainly not under the general maritime law of the United States, there would be a requirement for a hold harmless to be established under clear evidence, very clear evidence. And the burden would be on the parties seeking to show that a hold harmless exists, to demonstrate on the clear evidence that this had been agreed. And the evidence here, I think, is ambiguous. That email from Mr. Tsatsis, if anything, I think was quite carefully crafted to be ambiguous. It said, grateful for your confirmation. It didn't say, we are grateful. It didn't say we will be grateful. It made the tense, I think, very indeterminate. I don't know, but I suspect that that was deliberate. But even if it wasn't deliberate, it was ambiguous.
And so I don't think that that document in any way demonstrates on clear evidence the existence of a hold harmless. And as for the oral evidence, I thought that the statements from both of the witnesses were plausible. It was perfectly plausible that Mr. Van Blanken, while under pressure to give a hold harmless, would be evasive and not want to give one. And that's what he said he did. And it was also plausible that Mr. Tsatsis would want an indemnity or a hold harmless, given that the oral evidence, to my mind, was inconclusive, and the written document was, to my mind, ambiguous, and perhaps deliberately ambiguous. The burden was not met by the party claiming the hold harmless that it existed.
Now, the second point, was the port unsafe when the vessel was ordered to call there? It was common ground that there had been groundings at the port over the previous 10 years, and on occasions vessels had touched bottom or had lost speed, but no vessels had come in contact with the underwater obstructions. Now, every port in its natural state has hazards for ships calling there, but will not be unsafe if reasonable measures are taken to overcome those hazards. At Port Lindsay, there was a system in place to maintain the proper positioning of the navigation aids and to monitor the draft in the river, and that system was implemented. The Port Authority held what we might call a case conference meeting over that particular transit. The first pilot to board the vessel on arrival advised the master to request updated soundings. The master was immediately made aware of the underwater obstructions and the heavy rain causing difficulty in the river. Tugboats were available and they were used. The situation in the river was due to heavy rain, which was not a normal feature and so did not make the port inherently unsafe. The soundings in the river and thus the depth in the channel were changing more rapidly than usual. That situation was abnormal. The pilot had said that in his experience, no vessels proceeding to bore number 7 on 30 feet or less had touched the underwater obstructions. Our one reservation about the safety of the port was the underkeel clearance, which we consider that a 1 foot clearance was insufficient, and to that extent the port was unsafe. The question is, what was the effective cause of the grounding? The underkeel clearance, or lack thereof, or the master's miscalculation on squat? And in our view, it was the master's squat calculation, or miscalculation. He underestimated the effective squat and proceeded upriver when he should not have done so. A master is expected to assess the danger proceeding and wait if he considers it necessary. It appears that in normal conditions, the risk of collision with the dangerous obstructions could have been avoided with ordinary skill and care. As we said before, no other ship had touched the obstructions on the same draft, so it was not inevitable that the ship would hit the obstructions because of the underkeel clearance. The master's miscalculation did make it inevitable. He did not apply the required ordinary degree of care and skill in calculating squat, and as a consequence, struck the underwater obstructions. Now, we accept that the pilot did agree with his calculation, but the pilot, notwithstanding the alteration to the charter party, remained the servant of the owners. We do accept that the master was entitled to load the ship at the loading port to a draft of 30 feet fresh water. He was just simply doing what any commercial person would have done on those instructions. But nonetheless, we consider that the master's negligence in calculating squat did obliterate any breach of the charter's safety warranty, and that the owner's claim must fail. Add anything?
I agree with the conclusions, but I will simply elaborate by reference to what I understand U.S. law to be in this area. And American law is a little confused in this area because we have some conflicting authorities. In the Fifth Circuit, which is for the U.S. Gulf, there is appellate authority that the safe port warranty is only a warranty of due diligence on the part of the charterer to nominate a safe port. And I think if that were the standard, there would be, despite the language in the Charter Party, there's a possibility that a court or an arbitrator following that authority would find that there was no breach of that obligation. But I think that authority is wrong. I think that the controlling authorities that New York arbitrators would follow, or I hope they would follow, are in decisions of circuit courts in the Third Circuit and Second Circuit, which are nearer to New York, which say that the Eastern City, the English Court of Appeals case, is good authority and correctly states the applicable American principles. And so if we apply the Eastern City principles as reflecting American law, and the formulation being that if the unsafety of the port can be avoided with the exercise of good seamanship and navigation, then there isn't a valid claim for breach of the safe port warranty. And applying that principle, I believe the right conclusion under American law would be the one stated by the chairman. And for the reasons he's given, I don't believe that construing the voyage instructions, the master can be faulted, particularly given the provision that the vessel would be lighted if the draft, if the available draft in the river was less than 30 feet. The vessel would be lighted. I don't think that the master can be faulted for having loaded to the draft that the vessel was loaded. The point where the master, I think correctly under American law and in accordance with what the chairman has stated, acted negligently and to such a degree that it can be said that bad seamanship was the effective cause and not the unsafety of the port, is the decision to proceed without having, or not without having made squat calculations, but having made fundamentally faulty squat calculations. I asked Mr. Phillips whether his view, to address Mr. Tsatsis's evidence about permissible draft. And I was concerned that not sufficient consideration perhaps had been given to whether the master fairly had relied on the statements made, the erroneous statements made by the harbour authorities, that with 30 feet it was safe to proceed, and that in doing so he had relied on that, thinking that squat had been computed into those figures as to what the permissible draft was. But as Mr. Phillips pointed out, and I believe it was agreed evidence that the agreed facts, the master had in fact calculated squat. He'd just done it wrongly. He'd made a fundamental error in calculating what the squat effect would be given the current. And so the question then would be, under American law, and the same would be, is clear from the English authorities, whether the master's error was of such a magnitude that it, to use the word in the English authority, obliterated the breach of the safe port warranty. And I certainly struggled with this because one feels for the master. He was placed in a terrible predicament. But the error here on the squat calculation is, based on all my understanding, and I'm not a navigator, but based on all my understanding, was an extremely fundamental error. It is akin, I think, to an owner not checking a contract to see if there's a time bar. It's a very, almost, one of the most fundamental principles in determining whether a ship can safely proceed from an estuary into a river to take into account the effect of the current on the vessel's draft, the squat effect. That wasn't done properly here. And it seems to me that while it's not recklessness, it wasn't the conscious disregard of an unreasonable, of a terrible risk. It was what in, and there is a concept in New York law of gross negligence. It's kind of difficult to apply it in principle, but it would be that it's not a mistake that any reasonably cautious master could fairly make. And this was, I think, a very serious error. And so it did have, in my view, that obliterating effect. And therefore, if we were applying American law, I think we would come to the same conclusion that the chairman has stated.
I think I would agree with that, especially with respect to the position, or certainly with what the master did with respect to his calculations on squat. I think it does just obliterate everything else. But I also agree with the submissions of the charterers that I think, irrespective of the voyage instructions, I think there were just too many red lights that were, or certainly amber, which was turning to red, which was there from the very beginning. And we've seen that there is evidence that the underkeel clearance ought to have been something between 6 and 24. I think given that there were these red lights, there was a necessity for the master to have been more cautious with his passage planning, and the ultimate responsibility for the safe navigation of the vessel was always with the master. And with these warning signs already there from the beginning, I think it was not prudent to have loaded the vessel to the extent that she did. But having said that, and I think the sort of slight twist, I'm not sure how the issue of cost would be dealt with, but given my own thinking, if I was doing this on my own, then given the fact that the charters have actually succeeded on two of the arguments before us, but of course failed in the most important one, and so the owners succeed, I think on the issue of costs, I then would only award, say, 50% of recoverable costs to the owners, because a lot of the arguments that were put before us, two of those actually went in favor of the charterers. So although the owners succeed, I would award them only 50% of the recoverable costs. But you want to do something with costs?
Do we have time? Right.
Robert, you could say something about costs in US proceedings now, or US arbitration, I should say.
Go ahead. Well, traditionally, costs in the English sense, which means fees and expenses, in America, normally costs just mean disbursements, has a much narrower meaning. So, but if we're assuming we're talking about fees and expenses, including lawyers' fees and expenses, costs were not awarded unless the charter party had an express provision authorizing the panel to make an award of fees and expenses. That, however, has changed now. If both parties in their final submissions ask for an award of fees and expenses, that's deemed to be implicitly an agreement that the panel can make such an award. And beyond that now, there is authority that arbitrators can award fees and expenses under the general statement that any disputes or controversies arising out of this charter would include an award of fees and expenses. But because the giving of fees, making of awards on fees and expenses is a relatively new phenomenon. It's only really been taking place in the last 10, 20 years. There isn't the same developed body of principles on costs following the event, and ideas such as sealed offers and all these things that are quite developed under English practice. And so arbitrators tend to do what they think is fair. And in a case like this, I think that although there were some issues that didn't go entirely in the Charter's favour, I mean, they were not issues that were argued without having a colourable basis for being argued. And I think that provided the fees appear to be reasonable, they would likely be awarded in their, all or substantially all of them would be awarded to the owner. Sorry, to the charterer, to the prevailing party. Yeah.
Good, I'm on there. Thank you very much to the tribunal. It's very interesting. Thank you for explaining it as far as American law is concerned. That's very interesting indeed. Now, you will realize, of course, that the arbitrators have disagreed with the majority vote of the audience quite substantially. So what we'd like to do is invite you, and put the lights up, to ask questions of the tribunal. I think there ought to be some questions because, as you know, the tribunal disagreed with the majority of the audience. So can I throw the floor open for you to ask any questions you like? I think you'll get a microphone.
Line 3, where it says here, actually a phrase, active pilot, is struck out. And why is it that the owners are liable for, the act of the pilot, even though this term was struck out? Statements.
Who would like to answer that one?
Well, it was struck out in the Charter Party, but in the law generally, the pilot is the servant of the owners, and he remains so in this instance. The charters were paying for the pilot as they would do normally under a, under a time charter, but that did not shift the, should we say, the responsibilities from the for the acts of pilots to the charters. They remained with the owners.
I would answer that slightly differently. I mean, I agree with that, but we found that the effective cause of the grounding was the negligence of the master in failing to do an accurate squat calculation. That really is separate from the pilots or from the harbour master. That was a duty that the master had on his own, that the owners had. And so the fact that active pilots is struck out in that clause doesn't bear on that particular act of negligence.
Can I just raise one point? I'm glad you made that particular observation because I deliberately cut that out of the charter to confuse things a bit. Any other questions?
I was one of the 70% that thought the charters were outrageous in sending a poor, helpless master up the river against his better judgment. But given the facts and the interpretation of the law, I understand that now. But I'm intrigued as to how this tribunal, if the tables were reversed and in fact the charter was claimant and the owner was respondent to a claim for damages because the master refused to proceed upriver, loss of hire or an off-hire claim, damages for potential adjustment to the value of his cargo because he didn't discharge before the 30th of June. How do you anticipate this might have been perceived in proving that it wasn't safe?
You're nodding, going to answer that?
No, I think it's a very good question, and it's certainly highly plausible that the charterer would have said, the Port Authority says it's safe, the pilot says it's safe, and your master's refusing to go, and in those circumstances you're liable for, we're going to put the vessel off hire, and if we lose that sales contract, we're going to claim for the loss of profits and for all our incidental damages. I hope that the same panel, if faced with a claim like that, would have given great deference to the owner, to the master's right to err on the side of caution, and that the burden would have been on the charterer in those circumstances to show that the master's refusal to proceed was clearly unreasonable. And I would hope that as a panel we would be subjecting the charterer to a very heavy burden of proof in questioning the master's discretion as to what was safe for the ship.
It is in the English case law that the master is permitted to delay until he is satisfied that it is safe to proceed. I think it's the Sussex Oak, is that right? Yeah.
Nodding going on.
Thank you. So I think that under the scenario that you presented us with, we would, should we say, find accordingly in that case for the owners.
Can I have one wrinkle to that, which is this, that the basis of the tribunal's finding in this case is that the only reason that the vessel was at a, let's call it a dangerous draft, was because of the master's negligence in failing to make due allowance for squat and underkeel clearance. And that possibly introduces a further variation into that particular dispute, because then you've got a situation where the master says, well, actually having thought about it, I'm actually not prepared to proceed. And the charterers would then say, yes, but the reason for that is because by virtue of your negligence, you're at the wrong draft. And you may find that that actually sort of addresses or readdresses the balance that's just been under discussion.
Other questions? Several questions there.
Thank you. A lot of what you said in the end relied on two things. One was talking about the email between the two gentlemen and how that could be misinterpreted. And one was about the masters working out of the squat. And by the end of it, a lot of the responsibilities come down to the master and the things that the master's done wrong. Now, to me, it's quite clear that the one person that's not here to give any proof on their own side is the master. Is that unusual that someone who can be ultimately responsible for the outcome isn't here to justify their position in any way?
Well, I think that in a normal hearing, that the master would be presented to give evidence, yes.
Yeah, Bruce, can I say something there? You're quite right. In the actual case from which this was derived, the master did indeed give evidence and was cross-examined. But this is a mock arbitration, so we had to have agreed facts, I'm afraid. Now.
Yeah, hi. I'm but a mere class surveyor, so the legal side is a little bit outside of my remit. My question is, what's the sort of mechanism and the process by which you follow as counsel to actually establish your line of defence or your line of inquiry, and how you actually get to this point into the arbitration?
Well, there's a broad question.
We make it up as we go along.
Yeah, we make it up as we go along. We do it every day, and it just... I mean, actually how we do it, you read the papers first of all. You try to work out what happened. You would often do a chronology, for example. And then it presupposes a degree of background knowledge of the law, because you can't determine which facts are relevant until you know the law. And then you don't know which law to look at until you know what the relevant facts are. So it's a bit of going backwards and forwards from the facts and the law, and then trying to work out where you want to get and how best you can get there. I'm not sure that I can be any more specific than that, but perhaps Neville can.
No, I don't think I can usefully add to that. I mean, I think what Chirag says is right. I mean, every barrister has their own method of approaching something, but I think by and large we all start by reading the papers,
trying to work out what the main threads of the case are, what the main lines of dispute normally identify themselves fairly readily to you simply by virtue of the fact that you have a knowledge of the law. We've often, hopefully, done these sorts of cases several times before, so you know the sort of red light issues, the things that sort of stand out to you, and you think, okay, I'll remember that. And then it's a little like, I think I'd probably compare it to one of those children's puzzles where you have a load of squirrely lines on a piece of paper, but only one of them gets you to the center of the maze. And it's a question of identifying which squirrely line is the right one. And you use the authorities as sort of signposters to show you the way, and then you work your way through the papers, and then you identify the arguments, obviously, that help you, but just as important, perhaps, is to identify the arguments that if you were wearing the other shoes, you would be raising, and then you try and work out a way to head those off at the pass, so that what you've actually done is to craft not only your own case, but perhaps at the same time craft something which heads off each prong of an attack that you anticipate coming from the other side. But often what happens is that because you're representing one party and you're more heavily focused on, as it were, crafting and creating your own case, it's not possible to anticipate every single point that will be raised by the other side, because he's busy thinking about extra points that will help him. But equally, it's the same for him as it is for me, so normally it all evens out. Normally I win.
I was just wondering, Jude, whether you wanted to say anything as an advocate in Singapore.
Yeah, no, well, not really from that perspective, but I was just going to say that, it's equally important that it's got to be packaged in a way that's going to convince, that's going to be easily understood, quickly understood by the arbitrators. So you need to create a path which is going to be attractive to the arbitrators and one that we can follow very quickly. Then you get the advantage. Because if you want me to work with a difficult, convoluted argument to try and, it's a brilliant point, I'm sure, but if you're going to lose me along the way, then it's pointless. So that part, I think, is really important, certainly from an arbitrator's point of view, and from if you have a simple mind like mine.
Yes, more questions? One at the back there, one down here. Lots of questions. Can you get a microphone down the back, perhaps?
Hello, Charles Noakes from BIMCO. I'm trying not to be obtuse, but I'm very concerned that poor old Master's been very much sort of shafted here. The squat figures, I probably was asleep when you were discussing it, but for me, one of the most important parts of the squat figures is actually very much driven by the speed and course of the river and tidal races and obviously tide tables. And I'm just wondering how much analysis of the Master's figures, and that probably in the paperwork it says it was detailed and he got it wrong. But given there was so much play made in your discussions on the state of the safety of the port, given the tide, the movements of the sandbanks, the effect of current, did you actually give the Master any due deference in your considerations on that?
Well, yes, we did. But the deciding factor for us was the fact that the Master made his calculations based on speed over ground. And anyone who's familiar with squat knows that that is calculated based on speed through the water. So he was assuming a speed of 1.5 knots, or 1 to 1.5 knots, when in fact he should have been using something like 7 to 7.5 knots. And that was, we considered, such a fundamental error that it did obliterate whatever breach of warranty was on the part of the Port Authority.
Who else had a hand up? Can we get a microphone over there?
Thank you. Dimitri Mounioudis from R&K. I have a more general question to the arbitrators. Do you always rely on the line of questioning that is set by counsel, even if they are digressing or maybe not following something which you consider to be more pertinent?
No, We do try to keep them on track and do interrupt and stop them if we think they're going, should we say, going adrift, if that's the question.
Would you be able to set questions of your own which are totally independent?
No.
Not if
Even though you have great experience and you could ask other things?
What we would do is, if we had a question or thought there was a line of questioning that should be pursued, we would put it to both the parties and ask for them to comment. We would never go away from a hearing and make a decision based on what we thought was the case without having allowed the parties to comment on it.
Okay. Anyone else? Yes, another one over there.
Hi there, this may be something of a layperson's question, but what happens to the master now? Because I'm not quite sure, not having a level of shipping or maritime experience, whether his miscalculation was just ridiculous incompetence or an accident in the heat of the moment, or when he was placed under pressure. Is he likely to be chased to recoup part or all of the costs? Is he struck off? I mean, what happens to him?
I think you could address that to Mr. Satsas, I think.
Yes. John, do you want to answer that?
I think that if the error was of such gross fault, one would have to question whether that captain would remain employed within the company that had given him the command of the vessel.
Lindsay, I might advise Mr. Satsas not to sack the master pending the appeal.
Of course.
Because that might be seen to be an admission of guilt.
I think that's a very fair point. And of course, there was no appeal because it was decided on the facts. But,
Yeah. I was wondering if I could ask whether...
Of course.
I think the position under English law is, I know the position under English law is that one does have a right of appeal subject to the leave of the court. And I wondered if the tribunal could just clarify for the audience whether there would be a similar right of appeal in Singapore or in New York.
Good point. Who goes first?
The position in Singapore is that there is no right of appeal under our provisions. So unless you're going to look at some breach of natural justice or one of those sort of very fundamental issues which strike at the roots of justice. Apart from that, once you've decided to go by way of the arbitration, then it ends there. So there's no right of appeal.
What about New York?
Effectively, there would be no ability to appeal this award. There are two grounds for appeal in the Federal Arbitration Act. This would be governed by the Federal Arbitration Act. They are corruption, bias, that would have to show dishonesty on the part of the panel. And the other one is something called manifest disregard of the law.
Oh, yes.
That it virtually requires the panel to say in the award, we know that the law is X, but we're going to decide why. And given that we haven't done that, I don't think this award would be subject to challenge.
Do you know any New York awards that have been successfully challenged on that?
There have been awards that have been successfully challenged where panels have made statements to the effect that they're not applying the law because they think it's wrong, and they think it's wrong normatively, not wrong as in the sense that it doesn't represent the law. But those are very rare cases, and experienced arbitrators generally don't use language like that.
Quite right. No, it's a good point that Ian made, because you can apply for leave to appeal under Section 69, which is quite difficult now. But what's happening more and more is that people apply also under Section 68, which is misconduct, sort of hoping that they might get home on one if they don't get home on the other. I digress. Any more questions? At the back there?
I was going to ask this question actually before the bit about the US law saying that it's you could appeal if it was against the legal thing, because I was thinking about this in practical terms, as I'm not a lawyer. It takes ages to load sugar. It's a relatively long voyage. the rain was apparently abnormal. I mean, are we not being a little harsh on the master? How is he to know that it might rain once every 10 years and cause huge problems in the river?
Who'd like to answer that one? I think the answer is it was in the pilot, wasn't it?
I think all of the panel feels sympathy with the master, and certainly thinks that this was a dangerous port. But the legal test is that danger alone is insufficient. You know, the sea is dangerous. Many ports are dangerous. The legal test, which I think does represent American law as well, is that if the danger could have been avoided with the exercise of good seamanship and prudent navigation, then it is not an unsafe port within the legal test. And that is the test applies, and it's important that it be applied with some degree of predictability and certainty. And the master is in charge of the ship's safe navigation, and perhaps for policy reasons it's right that the test should be quite strict. That doesn't mean we don't sympathize with the master, but I don't think that would alter the outcome.
No. Anyone else? Or there's one in the middle there. Yeah. Can we get a microphone in the middle there? Thank you.
So my question is, for the Singaporean, you gave 50% cost to the charterer, to the owner. He has to pay the charterer 50% of the cost. Because I really didn't get that part well, and I just want to understand it.
Sure, go ahead. No, so what I did was I gave 50% recoverable costs to the owners, which would mean that if they, at the end of the day, would have been entitled to 100,000 pounds, they would recover 50,000. It doesn't mean they get 50,000. It means they pay them 50,000 instead of 100,000.
Then I would have wanted to ask of issues of contributing negligence on the part of the charterers.
No, no, it's not. It's because I'm just looking at what transpired at the hearing. And at the hearing, although, you know, in the normal course of events, the costs follow the cause. The winner gets costs. But in this case, although, as far as I'm concerned, they won. But on two of the points that were argued before us, the charterers actually won. Right? So I'm not inclined to give 100% cost to them because they actually lost on 2 points. So from that perspective, I'm saying to be fair, I'm only going to award them 50% costs. So this area is to the, it's up to the discretion of the arbitrator. And he can decide, how much cost he's going to award. So technically there were sort of 3 points being argued, but I've given them, so I didn't say you only get 33%. Instead I gave them 50 because the point that they won on was one where we actually had to hear witnesses. Otherwise we could have done this on paper. There was no need to have a hearing, right? Everything was agreed, facts were agreed, but they were going to put us through this hearing. And then they've won on that point. So I said, instead of 33, I give them 50. Perhaps I should have explained that a bit more. But that was my thinking, So instead of giving them 30% or 33 or whatever, I gave them 50 because they won on the point that actually required more effort on the part of the arbitrators and of everyone else. So that was my thinking.
Okay. Then this is just another general question. So in terms of who covers for liability, will it be the P&I clubs in this case for the ship owner?
Was that a question for the panel?
For anybody.
There's a P&I club man here. Yes, I can see one. No? No, well,
it's
not covered.
Sorry?
Well, the pollution or
the initial liability for pollution would have been covered by the P&I club.
Yeah, so that was this morning.
And there now, the owners were trying to reclaim the sums that they had expended and the fines that they had been forced to pay from the charterers on the basis that it was the charterers' fault.
So I hope that helps.
I mean, if I can explain, I think I mentioned that this was based on a real case, and the pollution case on which this was based was in effect fought between the owners' club and the charterers' club. So both clubs were involved in defending and indemnifying.
I actually have a question for the tribunal.
Why
I don't
did I
appear to be a
lose?
sore loser, but I just had
Something
one
you don't
practical
know.
question. Right. The tribunal has found that the master was correct in loading to 30 feet and proceeding to Port Lindsay, but he was wrong to have proceeded upriver. What would have happened had he behaved correctly? Would the vessel have just waited there? And done what?
Commercially, what would have happened
Yeah.
is that eventually charterers would have had to, someone would have had to lighten the vessel, no doubt at great cost.
Right.
No, they were entitled to insist on that.
Yeah.
And the ship would have stayed on hire?
Yeah.
Right, I think we're going to have to wrap. Is there another question? Oh, sorry. Oh, there's a very important question there. All the way from Denmark.
Thank you. Just accepting for a second that, yes, the master did act negligently. But then he miscalculated the squat effect, and then he did hit an uncharted obstruction. And thereby you are then saying, the way I understand it, that it was then an abnormal occurrence. And we are still waiting the outcome of the Ocean Victory as to how we have to interpret what is an abnormal occurrence. So do you mean that this uncharted obstruction was an abnormal occurrence in this port?
No, it was a feature of the port, but it was uncharted, sorry. At least I'm assuming, because the chart had been printed and no updates had been provided that would take those obstructions into account. But he was made aware of the obstructions and would have been aware of their location.
Also the location?
Well, of course he would. Well, if the pilots knew where they were.
Any, one at the back there.
Sorry, just following on from the gentleman's question, how would you know of an uncharted depth if it's not on the chart? How do you justify that comment? This is the comment for the chairman of the panel.
So, I'm sorry?
You said that the pilots would know of an uncharted obstruction. How would they know of the exact location if it's not charted?
Well, the pilots would have been aware of it from their soundings, wouldn't they?
Well,
there are surveys made in the
agreed facts.
Yeah, but that will be charted, isn't it? If the survey is made, isn't that the obligation of the port to put that on a chart?
I think the panel has found that if the master had refused to proceed because he had done a correct squat calculation, the vessel would not have grounded. And as a result, no claim would have arisen. And that his failure to do the correct calculation was the effective cause of the casualty. And so if that's,
he knew where they were.
that's the finding, and if it's factually true, we hope it is, it's not necessary to examine whether the particular chart showed the particular area of the grounding, I mean, of the obstruction. The panel has found that that if he had done the calculation, he would not have proceeded and the accident would not have occurred.
I'm afraid because this is mock arbitration, you have to go on the agreed facts.
Yeah.
And the agreed facts say that the pilots did know where the obstructions were, that they were near buoy number 7. So I'm sure if it was argued out in a proper full arbitration, it might be different, but the tribunal have to go on the facts that they have been agreed. Well, I think we're actually going to sort of have to wind up now because it's time for us to leave. They have another function here and we've got drinks outside. So can I just echo John Denham's thanks to you all for coming. Thank everybody else. One question, nice saying. I was just going to ask one question you didn't ask was what happened in the actual case? And the answer was the Charter has won. So it's consistent, which is interesting. Thank you very much indeed.